thank you.
I'm already,
I think it'll eliminate.
I'm
looking at
assuming for
2025.
public records purposes,
first round draft
but
picks, right?
there's really no reason we can't scan them and put them somewhere. You know, listen, I'm embracing the 20th century, 21st century. I don't even know what century we're in. This new one.
Just like me.
Yes, it sounds like a plan.
Good, how about you?
Phone's not ringing?
What am I gonna, what am I gonna do with those cabinets? I could bring Tom's stuff in.
Kind of the questions that come with these.
Yeah, I think give us another week or so, we can catch up on all the flood reviews. So we got, it'll be good.
Okay. Just cause.
I still don't think it's too late to have some sort of outreach with them, try to answer some questions, some questions on large scale. I didn't know that we had a video needed put out.
Oh, yeah.
That was really nice.
Oh, that'll need to.
Yeah.
Yeah, I did an article in the paper this weekend too, just kind of saying what substantial damage is and what that means, and you'll be getting a letter, what to do afterwards.
You traveled for holidays?
I don't want to fight it. I've done that for years and years.
Yeah. I've gone home a few times, but I'll live on Tuesday.
Yeah.
Come back on Tuesday again. We didn't stay a couple of
You
weeks.
try to come back on a Sunday after Thanksgiving. No way.
The traffic even here, like going through.
What was the address?
Oh, yeah, that's always good.
Well,
So I drive my
oh,
wife's
that's
Fern Hill,
Eric.
which is outside Jacksonville. It's a 3 hour drive. First hour and 15 minutes is just good. And after that, it's new stuff.
That's a nice area.
What's up? We may be here a while.
When I worked a little bit over in Sanford. The only boat I saw was the size of the boat I had was on top of the.
Yeah, they have a marina there and they have those mega yachts there. Pretty impressive.
Okay.
I saw one in.
Just that way.
Sharon, good lesson. This is why I don't like Tracy checking people in. That's yogi.
Just to sit there.
I was gonna tell you so you could rewrite it.
His name is Yogi?
Yogi. It's Yogi Denisova.
Okay.
It's Yogi Denisova.
Okay.
She's good. Okay. Thank you. Okay.
One time?
Yeah, because one of them, see, I didn't know.
Oh, they
I think
cleared
it says
one.
all 400.
Stop it, look at color.
I drove to the.
Oh,
To fill it up to about $3,000.
Wow.
I had, the one I had.
Okay, that way we're good, not to be here. So.
I was the one that's thinking 100 miles an hour in an hour. That's insane.
It'd be nice to have the ability.
there'd be a better way to do this. I'm sure there is. I know you will. I know.
Sometimes they write like I write.
When we get
I get love.
like I was doing before. Yeah, I know we're gonna, cause I can't keep it. Right.
Thank you.
I'm going from 7 to 30.
I'm very popular.
So you have, I need an 18 reserve.
Yeah. Sister, husband.
Do you see anybody here at Hobbs?
For what? No, and I don't think they're gonna be here.
Full we're gonna have.
The attorney called me before the hurricanes, when we thought it was gonna be in October, and he said he doesn't think that yeah, and then the ATL. Then you can do whatever you like. I know you know. But in the beginning, it only showed him and the law was testifying, and then you would see some people. Now, scanning. Yeah. When my husband was off, he actually watches. Well, sometimes he'll text me and he'll say, your microphone's too close to your face. Because we're saying things that nobody should hear. Because I think I just taken some coffee and then I'm gonna get that way.
He'll text you so
Yeah.
that he can hear if
He watches it on YouTube.
Tom. That's all.
Pretty much. He would have nothing else to do, just tap. No, I know. No, but he is off today, so. Yes, he had a doctor's appointment. He's the only one I know that will take an entire day off for an 8 o'clock doctor's appointment. He's done. But it's also, it's like because of the way they route his calls, taking the half a day is
One
not
of the
an
things, you
option.
know, not, could be one or
I'm definitely about taking the picture. Oh, it's at 9 a.m. Perfect.
Yeah. Yeah. You gotta wind down from that point.
That's my problem.
Well, he kind of said at the meeting there, that it requires a lot of access to the park, so we got a little bit of control.
This is a good time of year for it, because things are typically slower on the holidays.
Well, it just needs to be instilled in the fireworks.
The more time we give it up front, faster it will go.
There's Christian.
Christopher Mansfield just did.
Good morning.
Good morning.
Hi.
Oh, it's a crowd. How are y'all?
Good. How you doing?
Good. Let me see. Isn't there normally another book over here? There's usually 2 folders.
Wait,
One,
yeah,
this is
oh,
the LDC,
yeah.
but
Did I not bring it? Thank you. Yeah, but go fast, because he can't start till you bring it in. Thank you. I thought I would have gone. It's the one of the Citrus County ordinances and his opening
I've got it somewhere in here.
monologue. She'll be quick.
Okay.
Yeah. No. It's probably why I'm not.
You
Good morning, everyone. The time is 9:07. I'm calling this hearing to order. This is the November Citrus County Code Compliance hearing, and for these hearings, we usually follow an agenda. There is a copy of an agenda posted outside today. The first item on the agenda is the call to order. We just had that. The second item on the agenda is the pledge to the flag. So I'd like to ask if you would join me in standing to the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everybody.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is regarding the minutes from the September hearing. We didn't have an October hearing, so are there any proposed modifications, deletions, objections to the minutes as currently formulated? All right, I don't hear any. I've reviewed it. It looks good to me, so I'll go ahead and approve and execute these minutes.
Staff update, abated and continued cases are listed out front.
All right. So, ladies and gentlemen, I do want to introduce myself and briefly describe how this hearing is going to work. My name is Christian Waugh, and I am a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing today. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you could pay attention. When your case is called, please come forward, and you will be placed under oath. If you're appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to present its case. The county will be presenting its case from this podium, and so when you come up, you'll be directed to this podium. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation, meaning that I don't even know what the case is about until the county has started and the county presents its case first. Once they're done, I turn to you to see what you have to say. And that will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case. I will also ask whether or not you are contesting the violation, meaning are you arguing that a violation exists or not? If you do not contest that a violation exists, I will assume that a factual basis for the violation is there and just proceed to ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case at hand and made as briefly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before any fine begins. You must fix the violation by the date that I give, or the fine will accrue for each day that you remain in violation. So, for example, if I find that there's a violation for overgrown grass and say that I give you 30 days to comply, but there will be a $50 a day fine if it's not brought into compliance. If it's not fixed in those 30 days, that's when the daily fine begins to accrue, not from today, but from the 30 days that I give. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county also has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county ordinance or regulations. I incorporate these into all my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, there will be additional costs. Although it has only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. You do have the right to appeal any order that I make today, as may be provided by law. Just a little bit of a preview. On average, these hearings go about 3 to 3.5 hours. That's no guarantee. It may be faster. It may be longer. The county works with me to get you in and out. In other words, the cases where you are here get called first. Cases where people are not here get called last. So we'll make our best efforts, and thank you for your patience.
Do you want to do Hubs Ranch first?
I do want to do Hubs Ranch first.
First case on today's agenda, Hubs Ranch and Grove LLC, case number 2023-1028, Code Officer Brandon Norman. Expert on the case, Land Development Director Joanna Coutu, page 18 of your agenda.
Okay.
Good morning.
Good morning. I don't know that you need to be sworn at this point. I'm just going to announce my order unless the county has anything else that it wants to offer or lecture me on. So what I'm going to do is I'll be issuing the written order, working with Lori on this. I am going to find that a violation occurred. I'm going to find that it occurred twice based on the evidence regarding the festivals that occurred on the property, but based solely on the fact that there were effects on the neighbors and the community. In other words, that sound that is exempt under the agritourism statute. You know, we can argue about whether agritourism applies or not, but what can't be argued is you have a right to enforce your laws to protect the neighbors. And I want to be clear, so I want to give guidance about what this is going to look like going forward, because I think that something tells me that'll be important for this property. Number one is, when we look at the statute and the exemptions for the neighboring properties, I think that includes any kind of nuisance type thing. So that could be noise, that can be smell, that can be parking, cars parking because there's not enough. So that's the one thing that I think is obvious. I'm not finding that there isn't a violation based on your other stuff. In other words, I don't think I have sufficient evidence to make a call about certain things. And I want to tell you what I looked at in the statute. In the statute, and I looked at other states that have similar statutes as well to see kind of what people look at. There has to be a connection to some kind of agricultural activity, all right? But our statute talks about ceremonial stuff. So even weddings, okay, we enjoy the farm environment. That's actually exempt under the statute. So I think that there are festival type activities that are going to be exempt under the statute. But let me give an example of something that I don't think is. It's not a great example, but this is the best I can come up with quickly. If they were running like a court reporting business and they said, we'll host a deposition here. Look at how great it looks outside the window. I don't think that's an agritourism activity. So doing that kind of a business activity really has nothing to do with enjoying the environment. Do you have questions about that? Okay. So I think that's kind of how I'm looking at it. I'm also not making a finding, though I have concerns, and I'm not sure the county really was making a case out of it, about the adjacent rented / Airbnb properties. I'm not sure that that's agritourism. I'm not sure that's really the case you were making anyways, but I just want to tell you what I'm thinking about it. I do think the tents are agritourism. In other words, people staying on the property to enjoy nature, I suspect that is a kind of agritourism. So anyways, those are the kind of the guidelines moving forward. I'm going to find that the violations, I'm going to issue an order saying that they did exist, that they were not present at the time of the hearing, but that they occurred based on the evidence.
Okay.
Are there any questions?
No, I appreciate the explanation.
Okay,
Thank
thank
you.
you.
Next case on today's agenda.
Hold on,
I'm sorry.
I did actually have a question. We did in our presentation address a number of buildings that were built
out permits.
Yes.
Are you finding that those are agritourism, so we don't have to, so the permits
No,
are
no,
required?
no, I'm not, because the statute specifically exempt, or it doesn't exempt. It specifically says those are not exempt.
Okay,
And I think, I want to make sure we're on the same page. I thought we were going to address that by a separate
Yeah.
That was-
order, the building
Yeah,
permit
that was-
issue.
That was separate.
okay, I guess that wasn't conveyed to me, I thought we were addressing
That's a
all of
separate-
it right now.
They conceded on that, and we
Okay.
came to an
You're right.
agreed
Okay.
order. Okay,
Okay, thank you.
good question. Thanks.
Next case, Christopher P. Mansfield, case number 2024-1473. Licensed Compliance Officer Timothy Williams, page 19 of your agenda. Expert on the case, certified building official Samuel Costa.
Sir, can I have you go to that podium, please?
Sorry about that.
So please raise your right hand. Stand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Can you please state your name, sir?
Christopher Mansfield.
Thank you.
All right, good morning.
Morning.
Good morning. And is this Mr. Mansfield? Okay, gotcha. Please proceed.
All right. Timothy Williams, Citrus County Licensed Compliance Officer. This is case number CE 2024-01473, Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permits for all construction or modifications of the Citrus County Code of Ordinance. The address is 6889 North Marmore Point in Hernando, Florida, 3442. Property owners Christopher Peyton Mansfield. I have good service via posting the property and the Canto Government Building. I would like to authenticate the following documents and request that they be admitted as evidence. Exhibit A, photos taken during the initial inspection on August 12th, 2024. Photos taken in my corrective action inspection on September 11th, 2024. And photos taken at my final inspection on November 19th of 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of my posting affidavit and a photo of the NOH posted at the property, a copy of the continuance letter, and a photo of that copy being hand-delivered.
And when you say NOH, that's notice of hearing?
Yes.
Yep. Okay, so it's just exhibits A and B?
Yes.
All right, so sir, the way this normally works, and this is for everyone, when the county is presenting its case and it's got documents it wants as exhibits, I ask you to take a look at them and let me know if you have any objection to them.
No, I already know what they are.
Oh, you don't have it? Are you contesting whether there's a violation at all?
No, I just inherited the property. It's there.
And I want to make sure I understand. So you inherited it literally like
Yes.
through probate or
Yes.
through death? Okay.
Yeah.
How much, I'll talk to them about it because I'm still not sure yet. Let's stipulate to the entry of the exhibits just so that I can have something to look at. But how much time do you think you need to fix this issue?
If we didn't have the storm, my roof and fence wasn't damaged, a couple months, so now like 6 months because I have to get my actual roof of the house repaired and everything now.
Okay.
And that is an entire, basically, room, built walls, ceiling, roof, floor, mid-walls, everything.
Okay. Thank you, Mr. Williams.
So it's not something I can tear down myself.
All right, let me take a look at these photos so that I know what's going on. Oh, yeah, okay, I think I see your point.
Yeah. I inherited it. The person who called on me was the person who paid for it to be built.
Well, I guess if you look up irony, there'd be a picture of that. So,
Yeah. It is my lovely stepfather. I got the house and he didn't, so he was mad, so he called on the building.
well, there's different ways to fix it. I mean, one is to, I guess, go through and get the permits and everything, plans. No?
No, I don't think
It's
so.
just a tear down?
Yeah.
Pretty much, yes.
Okay, do you agree it's a tear down?
Like if the walls and everything came down, it would be a nice porch. Past that, no, I don't care.
I mean, it looks pretty rough. Like there'd be a lot of work that has to be done.
Yeah, I would just have to redo the floor. That'd be nothing. Put some deck flooring down.
Well, before I hear from the county, then what's your intention? I mean,
Tear it
is your-
down.
It is your intention to tear it
Yeah.
down. Okay. Is
I
that
didn't
your
know.
understanding of what really is needed here, or is this all unpermitted?
Yes, it is, all
Okay.
unpermitted.
Okay. Well, I mean, if you're just wanting to tear it down, how much time do you need to tear it down?
Like I said, 6 months because I'm gonna have to pay somebody to do it.
Oh,
but
I
I have
see.
to pay for my roof and stuff to be fixed first because the storm caused leaking in my house and everything.
Oh, I see, because you got an issue on another property.
No, that property, but the actual house itself,
think the
a bunch of
second-
branches came down and hurt it. That's a bedroom on the back of the house.
I see, I see.
Yes.
I see.
I think in one of the photos, you can see a blue building with a window on
I
the
see
left
it.
Yeah,
side
that's
of
the
it.
house.
Okay, so it's an addition. It's not a
Yes.
self.
No,
All right, gotcha.
no. And the guy lied saying I was building it for the last 2 years. He came, he was like, no, it's been here. I was like, yeah, I
I
inherited
mean, it doesn't look like anyone's living in it.
No, God,
Um,
no. It has no electrical ran to it or nothing like that. It's just wood.
Yeah, I mean, I think he's stipulating to the fact that there's a violation, so I don't think I need to go through all the rigmarole, but, you can lay whatever record you want, but
No,
I'm gonna
it's-
find that there's a violation. The only question to me is how much time to allow. He's asked for 6 months based on, related hurricane damage. I know that I don't know what Citrus County's policy is, but I know that many counties and cities are trying to waive fees related to hurricane repairs, or at least work with people on that stuff. Do you have any objection to allowing 6 months to tear this thing down?
I do not.
Could you apply for the permit, like within 90 days? Because from there you have 180 days to,
He doesn't think that thing would be permitted.
I'm sorry?
He doesn't think that would be permittable.
No, not that, that's the addition on the back of the house.
Yeah.
Oh. okay.
Yeah, I just need 6 months to tear
I
down the
mean,
addition.
he doesn't need a permit to, well, I don't know, does he need a permit to tear this down?
Because it's unpermitted work. It's been there for like 5, 6 years.
Yeah, and I'm curious, I mean, from the county's perspective, do you need,
Is there electric in it?
No, there's no electric or
It's just
anything.
a structure, just wooden structure.
no, it's just,
It's just a frame basically that sat undone for
do you wanna see the
years.
photos, Mr.
No,
Acosta?
I've got 'em.
Okay.
Yeah, I'm okay with the 6 months.
All right, then I'll find, what's the county's recommendation on a fine if it's not done in 6 months?
Citrus County Code Compliance respectfully requests the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deemed sufficient. The amount was based on the actions of the property owner.
I believe that, Mr. Williams. So what I'll do is I'll find that a violation exists, give 6 months to abate the violation. And if it's not brought into compliance as ordered within 6 months, $50 a day.
That's
So
fine.
That's what the order will say.
And
That's
once it's
fine.
abated, he has to contact code to let them know for inspection purposes.
Well, I incorporate those,
Me and him we're cool.
We've
I have his
been-
number.
although we have a new order for him, so I don't know. Let's just make sure that's incorporated, but yeah, thank you.
All
thank
right,
you.
All
That's it.
right, cool.
Next case on next case on today's agenda, Kevin Sterling, case number 2024-1307. License and Compliance Officer Timothy Williams, page 30 of your agenda. Expert on the case, Samuel Costa.
Good morning.
Morning.
Hello?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Can you please state your name?
Kevin Sterling.
Thank you.
Is case number CE 2024-01307, Chapter 18, Article 1, Section 18A, after-the-fact permits for construction or modification of Citrus County Code of Ordinance. The address is 7907 East Gator Court, Inverness, Florida. Property owner is Kevin Sterling. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during initial inspection of July 16th, 2024. Photos taken at my corrective action inspection on August 23rd, 2024. Photos taken at my final inspection on November 19th, 2024. And photos from the Citrus County Property Appraiser's website, July of 22, May to August of 23, and May of 24. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the certified mail return receipt, and a copy of the continuance letter and a photo of that letter posted.
Continuance letter. So did I do a continuance, or did you guys do a continuance?
For the hurricane.
storm.
Oh, it was the
continued it.
hurricane. I see. Mr. Sterling, are you contesting whether there's a violation on the property?
No.
Okay. Have you seen these exhibits already?
Yeah.
Okay. Do you have any objection to them being evidence, just so I can look at them?
No.
No. How much time do you need to fix the issue?
Actually, I need to get a after-the-fact permit, they said. And when I went to do that, they said I needed to get engineered drawings, which I just recently got. I plan on turning that in today.
Okay.
And then they'll review it and we'll go from there.
Does that sound about right? Does this problem need engineering review?
Yes, sir.
All right, let me just take a look at it. I don't think the engineering's gonna be too complicated on this one. How much time does it normally take from, maybe there's quibbles in the engineering and then it goes back and forth. How much time on average do you think that process is?
Probably 3 weeks,
Okay,
3 or 4 weeks.
okay. So if I grant, does it abate at the time the permit is issued?
Correct,
Okay.
yes.
All right, well then I'll do 45 days. You're conceding that there's a violation, so I'll find the violation, incorporate, and just for the record, I'll always incorporate it into the orders that when it is fixed, when the violation is abated, there is a responsibility to contact code so that they can come and verify it, just to end, stop the clock, so to speak. 45 days to abate the violation, and what's the county's recommendation if it's not fixed within 45 days?
$50 a day.
$50 a day will do. That's it. Actually, is there anyone from the public who wants to be heard on this case? The man wanted a porch. All right, okay. That's it. Thank you, sir.
Next case on the day's agenda, mirrorhouses.com LLC, case number 2024-1494, Code Officer Cody McGuire, page 5 of your agenda.
Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name, sir.
Christopher Chambers.
Welcome, Mr. Chambers. And are you an agent or owner of AmirHouses.com?
Yes, yes, I'm the president of Amir Houses in Citrus County.
Gotcha, thank you. Have we had other cases with Amir Houses before? I just feel like it's a familiar name that I would remember.
Because he owns quite a few properties
Okay.
in this county, so.
Yeah, sure. A lot of
It wouldn't
development.
surprise me if we haven't.
There's a lot of development going on, no doubt. All right, thanks. Good morning.
Good morning. Cody McGuire, Citrus County Code Compliance Officer. Case number 2024-01494, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4195 North Gary Point, Christopher, Florida. Good service would be posting the property and posting it at the Cantal Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on August 3rd, 2024, corrective action inspection on September 12th, 2024, and photos of my final inspection on November 19th, 2024. Exhibit B is going to be the copy of the notice of violation, a copy of the notice of hearing, copy of the continuance letter, and a pre-hearing order.
Okay. Sir, I would like to ask you to take a look at these documents and let me know if you have any objection.
No, sir, not at all, and I'm fully aware of the property and what it looks like.
All right, are you conceding that there's a violation on the property?
Yes, sir, there is.
How much time do you need to fix it?
Well, I also have some evidence if it's possible, because we did have the sheriff's department come out yesterday, because I was at the property yesterday trying to make contact with the homeowner.
Yeah.
Or the tenant, and he refuses to answer the door.
Well, I mean, honestly, I believe that, but for my purposes, and you can introduce whatever evidence you want, assuming the county doesn't have a valid objection, but I really just need to know how much time you need to.
Well, we
Oh,
also
you're having
have-
trouble getting.
Well, we're also evicting him. This
Okay.
was filed on November 17th.
Yeah.
due, obviously, for a non-payment. So we're asking for at least 120 days, if not, at least for in the 60 days after we receive writ of possession of the home back.
All right, then let me take a look at these documents to see. I don't normally allow that much time even with an eviction, just so you know, because, I've done evictions, and normally when you serve, they've got 5 days to respond. There's an accelerated process that's available. But let me take a look and see what's going on here. For the record, these are in evidence, Exhibits A and B. How big is this parcel? It's bigger than a quarter acre, right? Is it? Anyone know?
Roughly, I wouldn't know unless I actually looked at the
Okay,
county how
all right.
big it actually is, but the property, what around the home and the driveway, the whole area is cluttered with a bunch of junk.
Yeah.
I think if Code also went out there, I think he was out there yesterday, there was an issue at one point where he was illegally getting electric from the power company, and he's also tampered with the water meter, because I think they cut the water off on that as well.
I do want you to show what you've got to the county, because I
Okay.
would like to have that in evidence, just so I
Just-
can look at it.
And according to the property appraiser, it's .31. of
Point
an
three
acre.
one, okay.
And we have been to the property several times to try to get the homeowner to cooperate with us, to let us clean it up. And he keeps refusing for us to touch his belongings, his possessions.
Okay, all right. And you only signed for this on November 9th, it looks like, according to Exhibit B anyways. So it looks like you've acted pretty quickly, although there was an original notice sent on September 12th.
And he did.
Why is it that?
He
so-
did clean part of it up, but then turned around and even more junk has appeared.
I see. So originally, it looks like there was a notice signed for on September 2nd by someone in Lakeland, Florida?
Yes, that would have been
An
Mr.
attorney.
Amir. Yes, or an attorney, yes.
Okay.
And matter of fact, as of that, I actually went out to the homeowner that time
Okay.
and talked to him. And that was when he politely told me, don't come back to his property.
I see.
And that's when I laughed and said, well, it's not
Well,
your property.
I
but-
mean, so I think, here's what from the special master perspective, so to speak.
Yes, sir.
This has been pending now for 3 months. And I see the records. You're now moving quickly and strongly, and I think it's gonna get it resolved. But it looks like the case was only filed 3 days ago or so. The cops were only called yesterday. I'm not gonna give 120 days. I really think you can do this faster. So what I'm gonna do is, I'm going to provide 90 days. What's the county's recommendation if it's not brought in compliance as ordered?
$250 a day.
Okay, so what we'll do is a $250 a day fine if it's not brought into compliance in 90 days. Now, if for some reason the eviction takes a turn, as I said, you can always appeal my orders, and there's equitable bases to deal with those. But I think you can get it done, so.
Well, like I said, once again, the property belongs to us.
Yeah.
But the possessions on the property don't belong to us. So how do we force him to remove his items?
Well, number one, in the vast majority of leases that I've seen, landlords require compliance with the law.
Yes.
And often have an opportunity to, at least, sometimes it says it, sometimes it doesn't, but they have a right to clean the property up. Now, That may be something you want to put in your leases going
If
forward
it's
if
not
it's
there,
not there.
we will make sure.
But number two, again, I mean, I've had evictions completed in 10 days. And
Actually, with our last one that we just had done, I think it was 28 days.
right, and look, you've written in your exhibits that you've introduced, it says they're 4 months behind. So they're not probably going to put the rent into the registry, and that's an automatic default. So I think you can get it done. That's why.
Okay.
And all right.
Yes, sir.
Any questions? Good,
sir.
Thank you.
All right, thank you.
Thank you.
Y'all have a great day. Thank you, Mr. McGuire.
Next case on today's agenda,
We got about 4 steps in real.
Glenn A. and Mary E. Bruce, case number 2024-0849. Code Officer Julie Wilkinson, page 6 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good morning.
Good morning. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number CE 2024-00849. Site development without a development order or permit, a violation of Citrus County Land Development Code, Section 4002. The address is 7166 West Haddon Otter Lane in Homosassa, Florida. Property owner is Glenn A. and Mary E. Bruce. I have good service via verbal with both myself and Lori Spiros, the legal secretary.
Can you repeat that?
A verbal.
A verbal, like, understanding that it was received, they admitted it.
Yes, so, because it was continued, and we mailed the continuance later, and we spoke with them on the phone as well, telling them that it was continued from last month to this
I
month.
got you.
I would like to authenticate the following documents and request they'd be admitted into evidence. Exhibit A, photos taken during the initial
I'm
inspection.
sorry, Ms. Wilkinson.
Yes, ma'am. Yes, sir.
Sirs, I apologize. I can't hear the witness over the voice. No, I mean, you're welcome to do it outside or to whisper maybe. Thank you. Go ahead.
Can you hear me better now?
Yes.
Okay. Exhibit A, photos taken during the initial inspection on May 9th, 2024. Photos from a corrective action inspection on September 11th, 2024. Photos from the final inspection on November 18th, 2024. And an aerial photograph from the property appraiser's website dated June 26, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the continuance letter. I also have Exhibit C, a letter to the special master written by the property owners.
Have I seen that letter yet?
I don't believe you have.
Okay. Are the Bruces here? All right,
No.
Yeah, I mean, whatever. No. Is there anyone from the public who's going to want to be heard on this case? Okay, I don't see anybody. The exhibits are admitted without objection. Thank you. And let me just look at these real quick. So the county's case is essentially that the lot was cleared without
Yes.
a proper site plan or approval of any kind.
Yes, sir.
All right, let me just look at this letter.
Mhm.
Is there any reason why this letter wasn't sent to me, or?
I don't know why it wasn't
Okay.
sent to you directly.
Well, no, I mean, code compliance received it. I guess I'm just curious why it wouldn't be sent. Usually I do, like when people have motions for a continuance or something like that. If it's just for the purpose that it's really just evidence in a hearing, I guess I can understand the county's policy. I'm just curious if there is a reason.
I think,
That's why? Okay, all right. Then let me just take a look at the letter, which has been admitted without objection. Okay, for what it's worth, I agree with keeping the letter till the hearing. Just looking at its content, I think that's correct. Wow. Well, I think that this is sufficient evidence to determine that a violation has occurred, to be honest, based on the photos where I can see that the site was cleared in comparison with the property appraiser photos, as well as the fact that they have conceded that they violated the code. What is the county's recommendation?
Excuse me. Due to the irreparable and irreversible material change to the property, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative costs.
I think normally what I've done on these cases is assessed fines of $2,500, which I'm going to do in this case instead of the $5,000 recommendation. Also, I'm persuaded that they were not well advised by the people who cleared the site, and that's it.
Thank
All right,
you.
Thank you.
Next case on today's agenda, Data Holdings 3538 LLC, case number 2024-847, Code Officer Alan Jonason.
They've asked for a little bit more time.
They asked for, okay, we'll go to a different case.
Oh, okay. And just a question to y'all then. Those are all going to be one case at a time, correct?
Yes, sir.
Yep, okay.
Next case on today's agenda, Nancy Suzanne and George Paul Henry Craig, case number 2024-1500, Code Officer Julie Wilkinson, page 7 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Thank you, sir. Please state your name.
George Popolo.
And are you an owner of the property?
I'm the primary caretaker of it, yes.
Oh,
Nancy Craig is my great aunt, so.
okay.
She left me the property to take care of and maintain.
Okay, just for the record, it's not like it's a lease relationship or anything, but you're like the familial property manager.
I will inevitably inherit the property.
I see.
Yeah.
You have an
So-
interest in the property.
No, I will end up owning the property. There's a huge confusion going on throughout the whole probate situation because she had passed away, then my grandma was supposed to inherit it, but it never got put into probate.
Oh, okay, so you're saying,
So once it goes through like 3 sets of probate, it'll end up in my name.
okay, but, so actually what you're saying is you are the heir.
Yes.
And you're what we call in the law, the beneficial owner of the property.
Correct.
Okay, that satisfies me. Go ahead.
Julie Wilkinson, Citrus County Code Compliance Officer. This case number CE 2024-01500, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A. The address is 7300 South Strait Avenue in Homosassa, Florida. Property owners Nancy Suzanne Craig and George Paul Henry Craig. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on August 22nd, 2024, photos from a corrective action inspection on September 20th, 2024, and photos from a final inspection on November 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
So this
I'm
is,
aware of it all.
well, so you have no objection to the
No.
photos and the notices being
Nope,
evidence?
yeah, no, I'm 100% compliant with the fact that I understand that there's definitely
An
the
issue.
violation. The only reason why the time frame has taken me so long to get it taken care of is due to sensitive information that I'm not gonna put out for a public hearing like
Okay.
this. But family situations that had come up that required a lot of attention, which is a whole different situation.
Right.
On top of that, I am a single income house, so,
Right.
but I literally just asked for it this weekend.
Oh.
Last weekend was primarily to get the side-by-side put back together because one of the parts were, I had car parts and stuff like that, which
Yeah,
it wasn't
I
car
see that.
parts. But we got it put back together, so this weekend was just picking up the rest of the trash and, well, push mowing the rest of my yard because that's all I got right now. And burning the debris from the hurricanes. I had actually gotten all the debris picked up, but then we had the hurricanes and now I have more debris, so I got more trees to cut down.
I was initially looking at the photos, gonna say, I really think you need more time than that, but in looking at the most recent photos,
I mean, I could.
it looks
if-
like there's been some improvement already,
Yes.
unless I'm mistaken, yeah.
Oh, we did a lot, and then, like I said, we had the hurricanes come through, and then my ex had actually left and took the kids with her, or two of my kids anyways, which we're getting them back. But that's a whole different thing.
Well, you know what you do with kids, you put them to work, so.
Well, one's
what
4
day-
and one's
No, no, no,
4
no,
months.
No, I'm joking.
No, actually, my stepson helps me a lot, so.
What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day, along with the administrative costs begin after the day you deem sufficient to abate this violation.
I'm gonna give you more time than the weekend. I think what makes sense based on the testimony would be to, well, I mean, find that there's a violation, but grant 21 days if that's, I mean, you got holidays too, you know, so is that sufficient time to get this?
Yeah, that's plenty
Yeah.
of time. 21 days, I can get it done in that
All right,
time.
if it's not brought in compliance as ordered, there will be a fine of $100 a day, but otherwise, you're done.
Okay, thank you.
Thank you.
Thank you.
Oh, I'm sorry. Is there anyone from the public who wants to be heard on this case? Okay, I'm sorry. I should have. Yeah, and sir, if you would remain, the hearing is still open.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
My name is Daniel Nichols.
Thank you.
I live next door.
All
I
right, thank you,
filed a
Mr. Nichols.
complaint.
Sorry, I do want to hear from you.
Yeah, no, that's okay. This has been ongoing for a number of years. Prior to the complaint and after the complaint, I have offered the use of my trailer. I've offered the use of my lawnmowers. I've offered to come over and help do it myself. And I will continue to offer that. If I can do anything to help you, I would be more than happy to, and that's all I've got to say.
Okay, thank you, sir. Ma'am, would you like to be heard, or that was good enough? All right, is there anyone else from the public who wants to be heard? All right, I don't think that's gonna change my ruling, but I appreciate that feedback, and I hope that's helpful to you in some way, but the hearing is now closed. Thank you.
Thank you.
Next case on today's agenda, Data Holdings LLC, case number 2024-846, Code Officer case number 2024-847, Code Officer Alan Jonathan, page 8 of your agenda. Expert on the case, Joanna Katu.
And also, Mr. Charlton, I'm aware that there is a child who's been here, so I don't know if they're one of the parties or associated with one of the parties, so after this,
try them?
after the Dada cases, I'd like to take that.
Absolutely.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Please state your names.
Troy Burrell with Burrell Engineering, 12005 North Florida Avenue, Dunellen.
Ma'am?
Lisa Lanzarone, Office Manager for Padim Healthcare.
Okay. And before, I just anticipate the issue will be raised. Which case is this, by the way? It's the
This is 847.
847. All right, so the first one on the agenda. So normally, the folks who have standing to stand up on behalf of an LLC are the owners or someone who's been designated as an agent. What is y'all's role or relationship to Data Holdings 3538 LLC?
Well, I've been asked by the owner as
Yeah.
his consulting engineer to come up and represent him.
Okay.
I am the office manager who was part of the remodel project when the concern that we're discussing today came into play. So in relation to Data Holdings is the owner of the property, not so much, but if we are here to discuss what the violation is, I'm happy to shed light on that and help work through how we can mitigate the problem.
Well, the reason why normally we need either an owner or someone who's actually like designated as an authorized representative is it's possible that you really don't have any more standing than some member of the public, if that makes sense.
Well,
So-
yeah,
so
he's
to-
here present with us.
Well,
Yeah.
oh, okay, well,
Yeah.
if you don't mind, sir, is that you? Would you mind just giving your authorization on the record that they can speak?
Yes, I give an authorization to speak on my behalf.
And what is your name?
Darceling St. Martin.
Okay, and are you the owner or president or agent of Data Holdings 3538 LLC?
That's correct.
Can you, I'm sorry, Lori, would you mind can you swear or affirm that what you just testified is true?
Yes, I swear that I'm the president and manager of Data Holding LLC, and I give them the authorization to speak on my behalf.
Thank you, sir.
Thank you.
Okay. I think that's sufficient unless the county has an objection. I will allow y'all to stand there then and speak, but I'll first hear from the county.
Sure.
Thanks.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202400847. Citrus County Land Development Code, Section 4100, Site Development Without a Development Order or Permit. The address of this violation is 3538 East Gulf to Lake Highway, Inverness, Florida. Property owner is Data Holdings 3538 LLC. This property is .24 acres and is zoned GNC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 April 2024. Photos from my compliance inspection on 19 November 2024. And aerial photos from the property appraiser's website dated 26 June 2023 and 6 May 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the SunBiz, a copy of the property appraiser, a copy of the continuation letter, a copy of the signed certified mail receipt for the continuation letter, and a copy of the pre-hearing order.
Okay. So the way these normally work is I ask you to take a look at these documents and let me know if you have any objection to them being in evidence. It sounds like we've got photos, property appraiser aerials, and notices.
Sure. Yeah, no problem.
Now, I've been out to the site, but I just thought it'd be handy to look at the photos again.
Sure.
Yeah, I'm very familiar with it.
Okay,
Sorry.
thank you.
Okay.
Yep, we're good with it.
Okay.
All right, I don't hear any objections. They are admitted as evidence exhibits A and B. And also, are there any members of the public who are going to want to be heard on this case? Just so I know. All right, I don't see any hands. Are you contesting that there's a violation on the property?
Forgive me a little bit, I'm not necessarily, I'm an engineer, not an attorney. I don't know that we're.
Well, that means you know a lot more about a lot more things than I do,
Yeah,
so
I don't know.
thanks for reminding me.
But procedurally, there's no doubt that the gravel was installed, and as I understand it, there weren't any permits pulled. I know I wasn't involved in any of the design. However, there are some extenuating circumstances as to why it was done. Just to give you a real brief, and I'm sure Lisa could go over it better. But going out of the existing driveway is extremely steep. It's one of those where, from what the owner has told me, cars tend to bottom out going both out and in. I didn't do the design. And so they have a lot of elderly patients, and their concerns were they've had situations where I guess because of the steepness, people were getting out into traffic, horns blaring, slamming on
Right.
brakes. So they wanted another access to try to alleviate that problem.
Well, I get that, and so we'll get to that. I guess I was just wondering if this was going to be an argument about whether there had been work without a permit or an approved plan or not. It sounds like there's reasons, and we want to talk about, good cause and that kind of stuff, and that's fine. But first, I want to hear from the county.
Sure, and just a caveat on what he was saying, so this particular address is not a part of the access road or access driveway that they put in. This is the parking lot, and you can see that in the overhead shot as well. That, the driveway portion that he's speaking of about access, that will come up in another case.
So I see the aerial.
I'm sorry. This is the driveway.
Okay, so
Never mind.
this is, yeah, so from the property appraiser aerial, it
I
appears
apologize.
that this is a parcel that goes to the highway. It comes from the highway, so I imagine it is, so this is an access
Yes, sir.
parcel. Okay, well, I don't want to get in your flow. I just wanted to know
Yeah,
early on if they were
absolutely.
contesting or not.
I
But please proceed.
apologize for that.
That's okay.
On 25 April 2024, I conducted my initial inspection and observed the property to be in violation. On 29 April 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 13 August 2024, I conducted research with no permits issued, and as of my final inspection on 19 November 2024, the property remains in violation. I have not had contact with the property owner.
What would be necessary to abate the violation?
Joanna Cattoux, Citrus County Land Development.
Thank you. And I have worked with Dr. St. Martin quite a bit, and I was very happy to see Mr. Burrell here too, because that means we are going to move this forward. They can't have a rear access parallel to where they have it. I realize they have reasons for safety concerns, and I was talking very, very quickly with Mr. Burrell in the vestibule out there. There's some possibilities, but not on this road, and that's what triggered this complaint by neighbors, is all the traffic coming into their residential area.
So you said rear access. Can you help me understand?
Right. So their doctor's office is on 44,
Uh-huh.
and they have constructed a unimproved drive back to the rear Suzie Lane. And
I see that, so help orient me on this property appraiser. Yep, I see 44. Where's the office? Oh, okay. So how does that help? So it's access here, and then they go around? Okay.
they
all
come
right.
off this side and then access off the rear residential road.
I see. So it's not direct rear access.
It's not. It
indirect
actually has to
rear
veer
access.
because there are houses behind them. Yeah.
So are you telling me that there's no hope of using this parcel the way they're using it?
Correct. But we will work with them to try to get some alternative access, just not on that rear road.
What is the way to abate the violation then?
They would have to stop the access. Right now, they have a big sign saying exit this way, and that's the way people are doing, and it's unimproved, so close that off. And you
Well, and this may seem like a silly question, but, I mean, taking the signs out wouldn't be enough, because
No.
then so what do they need to do to close it off?
They need to restore it. Frankly, there were trees and stuff there. They can put something there to make sure that people don't. We have to work on the driveway. That's the next two cases. The parking lot, but the driveway itself would be part of removal, would help along with the parking lot.
And before I turn to the LLC, I guess I'm curious what the county's gonna be requesting here.
That one's yours.
Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000, remove access to the driveway, remove the gravel and the material that was put down for the driveway, stop access from East Suzie Lane, as well as the administrative cost to abate the violation.
Okay, so you're saying that a fine should be assessed because there's an irreparable,
Yes, sir.
site has changed?
Yes, sir.
But but you're also requesting further performance on their part?
To remove the gravel, yes, sir.
But you haven't proposed a fine or, if they don't do what you're asking. So do you just want the one-time fine and do you want me to, is what I'm saying making sense?
Yes, sir.
Okay.
So we have determined a one-time fine and a certain amount of time to abate and remove the gravel, remove the access, and as well as the administrative costs.
And if they don't do it in a certain amount of time, I'll give them an angry letter.
Yes, sir.
Okay, all right. I mean, sounds good.
At this point, if they continue to use it after we've given the order, it could become a repeat, in which case
Correct.
daily fines start accruing once it's certified as a repeat, and it could go.
Absolutely.
We've seen them up to hundreds of
Okay.
thousands of dollars.
All right, then I'll explain that. Now I'd like to hear from you in terms of, I guess I do see the access off 44, so why is this necessary?
So I'd like to speak
Yeah,
a little
that's,
bit,
I wanna
if
hear.
I may.
Yeah.
So thank you for all of that. And so just so you know, we're willing to fix the issue in whichever way we can. So
Yeah.
the solution is to figure out how to do that, right?
Right.
When we brought this medical practice for the seniors to Inverness, we quickly noticed that it was dangerous. It's not only so steep coming in and out, it's also on a blind curve, a blind corner. So we said, it didn't take us long to figure out that that was not going to be safe for patients coming in and out. So we looked at the situation and we saw that there was access to that back road on Suzie. Correct me if I'm wrong, if I'm incorrect in saying so. Those houses that along Suzie are commercial residential. So for us, we didn't think that there was going to be any issue bringing commercial access onto that road because that's how those are zoned. So we went ahead and put down the gravel, thinking that that was going to be appropriate because it's not, it's pervious, right? So we're not creating any drainage backup. So I understand the.
Although even when something's allowed, you still have to talk to them.
Right,
Yeah.
right. I understand, in which I understand where they're saying there should be an administration fee to pay. I think $5,000 might be a little bit high, considering that there are going to be additional expenses for us to restore, remove, make the correction. So if there's a way that we can look at reducing that number, I think would be a little bit more fair. 5,000 seems a little bit high. The whole objective was to keep the people safe, not to do any harm here. So I don't know if the issue is because the neighbors have a problem with people coming in and using that road as commercial.
It doesn't
but-
really matter what their problem is. I mean, because there's a violation, so it's, they could have said that we don't like the clouds over that parcel that day. It'd be irrelevant. In order to figure out what the fine is going to be, I think part of what I need to know is what the county is wanting to do on the other cases, if that makes sense. Because it looks to me like these are related. I suspect that they're related. I don't want to assess an unfair fine without knowing what the county is claiming on the other properties. And I want you to say what you have to say on this case as well, but you understand what I'm getting at. I view these together.
Sure.
All right, then before we get to that, is there anyone from the public who wants to speak directly on this case? All right, I don't see anybody. Can you tell me a little bit about the others?
Sure. Do you want me to just go into what we were going to ask for the other two properties?
That's all I want to know right now.
Okay, so for the other two properties, we were going to ask for a daily fine of $150.
Okay.
Obtain a permit, and along with the administrative costs.
On each of the other ones?
Yes, sir.
Okay, then that's all I needed to know. You're not asking for a one-time fine on the other cases?
No, sir.
All right.
Which other cases and which other properties?
There's two other cases on the agenda today, and one of them is 3556 East Gulf to Lake Highway. The other is 3564 East Gulf to Lake. They're all held by different LLCs.
Just to let you know, this is 3556, there's this 3564. So that's three different.
Oh, I see. It's all relative to the same project. They're just three
this
different
is a-
addresses.
this is a gravel
Okay, I
parking
understand.
And this,
Yeah.
because extended over, there's the end of the pavement. So both of those.
Okay.
I mean, it's
Okay.
all gravel, correct?
Yeah.
Yeah.
It is. It's all where the parking lot is, just three different addresses.
Yeah, it's all related.
Yeah.
And they're all adjacent.
They are all adjacent.
Okay.
and owned by the same owner.
Okay, great. Well, thank you. Is there anything else you want to present on this case as mitigating I think you're presenting mitigating
Yeah,
damage.
one
Yeah,
thing-
just to figure out what we need to do to resolve the issue. Ideally, it would be best to keep those people entering and exiting from the rear so that we can keep them safe, because it's uncomfortable to dump them out onto Highway 44 on a blind corner. So if there's a way for us to do that,
I don't know the way to do that, and the testimony from the county has been that it is not going to happen.
One thing and I haven't had a chance to talk to Joanna at length, but I know Dada owns kind of a block of property that runs from 44 all the way to Suzie, I think with the exception of one perhaps residence.
Right.
In the middle there, so they've got a block of commercial property there.
Well, that's not really for this hearing, that'll be for y'all to resolve, and it sounds like you're creative and I mean, this is creative, and not a bad idea, it's just illegal. So, I think that's for y'all to figure out outside the hearing. What I'm gonna do is find that there is a violation. I'll assess a one-time fine of $2,500. I mean, I accept the fact that this is actually in the public interest, right? And probably, the services that are performed at the neighboring property are to the public's benefit as well. So it's not punitive, but this is kind of what we have to do this as a deterrent value to make sure that people do go through the proper processes in the future. So there is going to be a fine, okay? Yeah.
All right, so just to clarify, the fine is $2,500?
And,
Okay, I'm sorry.
correct, and I will say that as part of the order, how much time do you think you'd need to make this inaccessible to people from 44?
Not from.
Or I'm
from
sorry.
Suzie.
Well, both ways, right? I mean,
No, you gotta have access to 44.
yeah,
They already have access from 44.
on this parcel?
There is a
I mean, on the
drive,
property
an entrance.
appraiser site, there's a billboard there.
It's in front of the next
That's,
building.
okay. We're getting into the next case. I'll show you the aerial.
I'd like to ask for 6 months, if we can have 6 months to remove, at least 6 months.
No, I know, but I'm only looking at this parcel.
Right.
Can we do 9 months then? Let's do 9 months.
Next to Suzie. That's the only access
Mhm.
that they have. This comes across.
With 2 months of the holidays, I'm booking,
Yeah, I
I'll
see
ask
that.
him. Yeah,
Right.
sure, scheduling.
Oh, so there's no connection to 44 here. Okay, I got you.
It's just the parcel goes
Okay,
along.
so how long, thank you. So how long do y'all need to close off access on Suzie?
Can we ask for 9 months to resolve the issue? We can, with 2 months
No.
of holidays? No.
You can ask for anything.
Okay.
I will not
How about
grant.
6 months?
To close off access to Suzie?
Well, it isn't so much
It's-
to close off, to create and solve the whole to remove the gravel, to clean up that access.
But that's not what I'm gonna order, to be clear. I'm not gonna order that the gravel be removed in 30 days or 60 days. Because that is subsumed in the one-time fine. You've changed the character of the property. So like that, unless I hear different from the county, to me, what they want is the use that is really affecting everybody to stop within a certain amount of time. And I'll talk to the county again. So that's why I'm asking you, how much time do you need to close off access to Suzie?
Can I ask you just a question of what would constitute an acceptable closing of that? I mean, is it putting a cable across the road, a couple of concrete barriers? You wanted all the gravel removed and
It's a good
some
question.
landscaping plan? 'Cause that's gonna depend on.
A couple of those would be perfectly fine, we're just trying to shut off access, so we can talk about it, but some.
Well, some are bad. Well, see, but that affects my, I'm gonna give, if it's easy, if it's a matter of putting up, mobile chains, that can be done in a day, so I need to have an understanding of what y'all need or want to see with closed access.
Agreed.
Definitely remove the driveway apron, down improved driveway apron on Suzie, and then put up some kind of barrier. And I don't like metal chains in a residential world, but something like that, or block bollards, something like that.
What it sounds to me like, if you want that medium road, they're gonna have to get a contractor in there with some equipment.
Restore the driveway.
And then probably do some kind of little bit of landscape work, as in dirt
So
work
how
or
long would that
mounds
take?
or something to avoid. you're probably looking at 30, 60 days just to get a contractor in there to do that, I would think. Just with holidays coming, and as busy as these guys are right now, getting somebody out there the next week is almost impossible.
God, I can't believe Thanksgiving's next week. You're right. All right, so what I'll do is, let me just take a look at the materials again very quickly.
45 days.
Um,
45 days is right.
I mean, and I'm talking about just the driveway.
I know.
Is that what you're asking for from me, by the way, is a time to stop access?
Stop access as well as remove that gravel.
You
that's
do
in
want the
that-
gravel removed?
Yes, sir, absolutely.
But isn't that the irreparable thing that's
But it still
subsumed by
has
the
to-
fine?
It still has to be removed.
Why?
Because it can't be, I mean, it could be, the growth could come back once that's removed. In other words, that lot could be restored to its original condition.
And if I may, this is
But then it's not irreparable, and I won't do a fine.
This is slightly different than I think of the traditional cases we see like this. Usually we see lot grading and clearing, trees removed.
Right.
That's irreparable. In this case, in order to put the driveway in, they had to do the grading, they had to do the movement. That's what we traditionally see. We have an extra layer here where in addition to that, they've added something else onto the property. And that in addition has made the additional development happen as well. So for example, if they had put a shed there, after they graded and everything, we'd still ask for the one-time fine because they've done the grading and everything that cannot be changed back. But would also.
Can't it? Can't grading be changed back?
Did they do a topography study of the land before they graded it?
You would
Well, all
have
that
the-
means,
And did
well,
they
no,
remove-
sir, it's okay.
Did they remove-
All that means is that, you know, you wouldn't be able to verify it. It doesn't mean that they can't put it back. It means we have an argument about whether they put it back or not. I'm not trying to split, it's just it matters whether or not it's irreparable. I struggle with doing a fine in this situation and then instructing them to remove the gravel. I think you're correct that I could order it, but what I feel is that that's more of a,
So if I could finish the county's position, just for the record. The tree removal, the underbrush removal, the grading, all of that happened in this case. Additional development of something being added to the property also happened in terms of development.
you said that.
Such as
yeah.
if a shed was there.
Yeah.
So that's why we're asking for the one-time fine, but we're also asking for the additional added development to be removed
No,
because that development
I
wasn't.
understand, yeah.
And so I've
permitted.
also heard from the neighbors, the adjoining properties, and the dust from that is like caking their property. So, and theirs is residential, I mean,
That is not a dusty parking lot at all. It's not drumming up dust like that. I disagree with that statement.
it's lime rock.
And I would like to have a better understanding also, you're saying the reason why. Why does that lime rock have to be removed? I understand where you're coming from in terms of shutting off access to Suzie. Seems to be something that we can do. Okay, we can maybe find an alternative way for patients to access and still keep safety. Sure, we can do that. But, right, then you have the fees to remove that gravel. Why? I would like to have an understanding as to why that's being requested.
Because it's not a proper use on the property. You're not allowed to do this, what y'all have done to the property, which is why, the reason why they're saying is, it wouldn't have happened at all if you had talked to the county and followed the law. But because you did not follow the law, there is something on the property that is not ever going to be approved to be there. And I don't really have any reason to disbelieve. I mean, it looks like you could have some dust out of this. I'm kind of surprised. I mean, it's not just pebbles. There's clearly,
There are no, in that parking lot,
Yeah.
our medical practice is to the right, and
Yeah.
on the other side of that is another piece of property that we own that's vacant right now.
Right.
Aside from that, there are woods behind it, so I don't know.
all right, what's the county's recommendation? I mean, you said you wanted a fine.
Yes, sir.
You wanna close?
And you just want me to give a time to get the stuff done?
Absolutely.
And they asked for
then
6 months.
And then close off the access from Suzie and the administrative fees.
All
And at
right.
a minimum, I'm sorry, at a minimum, restore the right-of-way on Suzie. That is a dirt apron. It's not lime rock, it's dirt. I drove it yesterday.
Okay.
Some of the photos, you can see the deterioration of the asphalt.
Okay,
from the
what I'm gonna do
vehicles.
is have a one-time fine of $2,500. I'll grant 90 days to fix the right-of-way, to block the right-of-way in a manner satisfactory to the county. And I will grant 6 months as requested to, if I understood the request correctly, to restore the, I don't know what you would call it, but the surface of the property. Okay?
so- Thank you for that. So just to gain clarification, when we're talking about restoring, just this driveway or everywhere that this stone is needs to come up?
So this is for 3538 East Gulf to Lake.
Can I see the
Which
image?
is that thin parcel
Okay.
that drive is on. It goes out to the billboard.
Okay,
Any gravel that's on, anything that's been modified on that parcel needs to be taken out.
okay,
And then that access from Suzie needs to be
closed off.
closed off as
Gotcha.
well.
Okay, so we have 90 days to get the Suzie access closed off, no problem, and 6 months to get the gravel off that parcel. Understood? Are we all clear on that?
Next case?
Yes. Data Holdings LLC, case number 2024-846, Code Officer Alan Jonason, page 9 of your agenda. Land Development Director, expert on the case.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00846. Citrus County Land Development Code, Section 4100, site development without a development order or permit. Address of the violation is 3556 East Gulf to Lake Highway, Inverness, Florida. Property owner is Data Holdings 3556 LLC. This property is .33 acres and is zoned GNC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 April 2024, photos from my compliance inspection on 19 November 2024, and aerial photos from the property appraiser's website dated 26 June 2023 and 6 May 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the SunBiz, a copy of the property appraiser, a copy of the continuation letter, a copy of the signed certified mail receipt for the continuation letter, and a copy of the pre-hearing order.
Is there anyone from the public who wants to be heard on this case?
So this is the same.
All right, I don't
There's some- yeah,
see
some
anyone.
I had to separate the photos per parcel, so some photos may overlap a little, but for the most part, they're spot on to where the parking lot is.
Yep, okay. Yeah, we're
And
familiar.
it'll show you in the aerials exactly what the property lines are, well, kind of, it's kind of off.
And the county on this case is
Yeah.
requesting, I think,
And see,
what,
this is another.
$150.
$150? Bless you.
Yeah, and I mean, honestly, it's the same thing, because once we pull the contractor in, they'll do it all at one time.
How much time do you need?
So, yeah, we'll do it all, when we ask the contractor to remove the access to Suzie, we'll do the whole project all at once, so I would
Okay.
say 6 months.
Well, what is, Mr. Jonason, what is, exhibits A and B are admitted. What is the, county, what is the issue on this parcel?
Again, they have put down lime rock, and made an additional parking lot on these, and then the next parcel will show it as well, the next case.
Okay, then I'm gonna find a violation. I'll assess a $150 a day fine if it's not brought into compliance within 6 months, to be
May I-
consistent with the other order.
May I ask a question? Is there any room for, fine, okay, it was done illegally, as you will, for us to keep it there, pay the fine, and look at an after-the-fact permit? I'm not sure how that would work,
Well,
or-
so I thought about that on the last case, but based on Ms. Katu's testimony, I didn't consider it because it sounds like it was never gonna be allowed. Is that the same case here?
Well, for the access to Suzie, I understand, but my train
I'm
of
asking
thought-
Ms. Katu
I'm
a
sorry, I
question. Thank you.
apologize.
That's all right. A gravel parking lot could possibly be permitted. That's why I was happy to see Mr. Burrell this morning. He may be able to permit it or remove it. Those are both options.
And that's why we're not going to
Okay.
do a fine, because it can be done. Like, if in the time I allow, y'all permit it, this thing goes away.
Okay, that's fair.
All right?
Well,
Next-
for those two,
Yeah,
the two, okay.
yeah.
I'm
Next
tracking.
case.
Okay, next case, Data Holdings LLC, case number 2024-780, Code Officer Alan Jonathan, page 10 of your agenda.
Alan Jonathan, Citrus County Code Compliance Officer. This is case number 2024-00780, Citrus County Land Development Code, Section 4100, Site Development Without a Development Order or Permit. This is case number I already said that, 3564 East Gulf to Lake Highway, Inverness, Florida. Property owner is Data Holdings, 3564 LLC. This property is .13 acres and is zoned GNC. I have good service via signed certified mail receipt and posting into the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 April 2024, photos from my compliance inspection on 19 November 2024, and aerial photos from the property appraiser's website dated 26 June 2023 and 6 May 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the SunBiz, a copy of the property appraiser, a copy of the continuation letter, a copy of the signed certified mail receipt for the continuation letter, and a copy of the pre-hearing order.
If you have any objection to exhibits A and B, please let me know.
They're all relevant.
Okay, exhibits
yeah.
A and B are admitted as evidence. Is there anyone from the public who wants to be heard on this case? All right. So specifically on this property, what's the issue? Same?
Same thing. Yes, sir.
And what is the county requesting?
A daily fine of $150, obtain the permit, as well as the administrative costs.
So obtaining the permit will abate the violation or removing everything?
Yes, sir.
Okay. So regardless of the case, I'll grant 6 months to abate this violation, however you choose to do it. If it's not brought into compliance as ordered, a fine of $150 a day will accrue.
Let me bring up, just real briefly, I'm sure they can get the gravel removed in the 6 months. There's no way to get this permitted, designed, permitted, and everything in place in 6 months.
Really?
No way.
Is that on your end or the county's end or both?
Both, plus SwiftMud, plus FDOT.
SwiftMud can't get through this?
SwiftMud, anything you turn in anymore, we turn in a permit. It's at least 30 to 45 days before we get comments. We turn those around, it'll be another 30, 60 days.
And this is just a...
Welcome to my
Yeah,
world.
no,
but
I mean,
any more a project like this, I'd tell people plan on at least a year to get it permitted. I could be over, and I'm just saying if you decided to.
Well, I don't care about SwiftMud. How long do you think it'll, does the county need SwiftMud to weigh in before the county issues a permit?
Well, they have the option of either getting approval with SwiftMud or approval with the county for
I see.
stormwater. They can do an either or.
I see.
And I don't know how long SwiftMud takes either.
County's not any quicker, I can tell you.
Perhaps we can, I don't know,
We had
check
one
back in
lady-
6 months. I don't know.
I will include in my order a request for expedited review on the county side. They don't care what I say either, probably.
And
but, you
I
know,
understand, and I just wanted to understand, I don't think he's gonna go this route, because I'm sure he's got other plans that, more than a little parking lot, and he'd hate to waste the money to go ahead and design it, permit it, then tear it all out in, a year or two, whenever he has the money to do the rest of it. But I do want to understand that getting the permit and getting the proper permits from all the agencies, you can't get one in 6 months anymore.
I think in extraordinary circumstances, if I've set someone up to fail, you can raise that issue on appeal with the county, and I take it up. So just let me know. All right?
Thank you.
Thanks.
Next case, Scott Robert and Caitlin May McMillan, case number 2024-1534, Code Officer Cody McGuire, page 20 of your agenda.
Cody, see if you can put that microphone down for them.
we have a microphone?
Thank you, sir.
Okay, that'll work. All right.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Scott Robert McMillan Jr.
Thank you.
Okay, good morning, sir.
Good morning.
Cody McGuire, Citrus County Code Compliance Officer. Case number 202401534, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 2053 West Astor Place in Citrus Springs, Florida. Property owner is Scott Robert Jr. and Caitlin May McMillan. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on August 27th, 2024. Subsequent inspection on September 16th, 2024. Corrective action inspection on September 30th, 2024. And photos of my final inspection on November 19th, 2024. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
All right. So, sir, you've been here long enough. Normally what I ask is for you to look at the documents and let me know if you have any objections to them being evidence in this hearing. And is that your child?
Yeah, all four of them.
Well, make sure that he weighs in because I'd like to know.
He usually has a lot to say.
Yeah.
So I'm actually surprised. He's been pretty quiet.
He's been very quiet. I mean, I wanted to get y'all in and out, but he's been very good.
He had to come no matter what, but the earliest we could get them to school was 8:50, so sorry.
And we have
I don't
a
mind.
13-year-old also that's at school. So.
Yeah. No, I was a little late because of my own today, so I appreciate it. All right, so without objection, what's been proposed as Exhibits A and B are evidence. And if you would, just give me 1 second to look through this.
Okay.
All right. Are you contesting whether there's a violation or not?
No, sir. We understand that there is an
Okay.
issue, which we have tried to rectify. Unfortunately, when the initial order was given on the 27th, I was actually getting ready to go to Tallahassee for work for a week and a half. I came back from work for a week and a half, 2 weeks, and then I broke my leg on the 23rd of September. And that has severely inhibited my ability to keep up with the property. We did hire a landscaper when we initially heard of the situation, which we intended to do before the violation was given, as well as the garbage situation. That was just from a large clean out of the house and just keeping up with things. The debris behind the shed, the reason why that is accumulated is because when we first bought the property, they did say that they offered a bulk pickup from Waste Pro, which was the initial company of the garbage that we had. Citrus Hauling.
Sorry,
Okay.
yeah, that, no, it was Citrus Hauling. When we bought the property, it was Citrus Hauling. They had bulk pickup when we bought the property.
I see.
Waste Management brought them out and then took away bulk pickup without any notice to, any notice to any of the residents. We didn't
Is that a
know.
contract with the county or is it a contract with you directly?
I'm not certain because
Okay.
we have 4 different garbage companies in our
Okay.
neighborhood, so.
And we have Waste Management people near us, but other trucks pick them up. So I'm not quite sure. When we bought the home, we just took up who the resident
Yeah,
before
Yeah,
was
of course.
using,
resident.
which was Citrus Hauling.
Well, listen,
now
I mean,
Waste Management.
it's not that bad. I mean, I agree. I think there is a well,
Couple of doors.
I've seen
Thank
a
you.
lot worse.
I
Okay,
appreciate
I've
that.
seen a lot worse today, but I don't want to make light of it either. I mean, I agree with you that there's a violation, but
course.
what I really need to know is how much time you need to fix
So we're
this.
struggling.
We were looking to see if we can get 90 days. Given my restriction, I have to contact family. I have family that lives about 2 hours away, but they all run on their own their own schedules and have kids and whatnot. So I was looking to see if we can get at least 90 days just to get my family all on one page so they can get together and maybe just get a trailer. Unfortunately, I can't afford a hauling service because I'm on 60% of my income right now because this is a work-related injury. So I'm on very limited
Well,
income.
I'll just talk through it with you a little bit. I just don't think it's like that bad. So let me explain what I see, and you can. And by the way, if I miss something that's part of the violation, let me know.
Yes, sir.
What I see is stuff in the backyard. I mean, is there stuff in the front yard?
There was nothing in the front yard. There was a fridge on the back porch.
There's a fridge?
Yes.
It's laying down, yes, sir.
Okay.
And that is still there currently.
Our second fridge broke and
We have been unable to dispose of it, so.
Well, by and large, what I'm seeing is just the stuff by the shed. But you're telling me there's more than that.
Just a few. The fridge, and there was a couple totes on the back porch as well with no lids.
Which we did rectify that as well.
Yeah, the totes were gardening totes. I
Okay.
didn't know because technically they're indoor totes, not outdoor totes, so they can't be outdoor. But he did tell me that my garden, greenhouse, my little greenhouse out there, which does not have the cover on, it ripped and blew off. It
During
wasn't
the
getting put
storm.
back on. He said that we could keep the totes in there, so we moved that. The only thing that's on the back porch now is my fridge and a Christmas tote that's coming in the house.
But yeah,
My
so
kids
that's
just
what I'm
brought
kind of
that out
agonizing
from the
about. It's
shed.
like what I
Like, we
see.
bring things back and forth. I'm sorry, I didn't mean to cut you off. Go ahead.
Well, what I see is, I see like a tarp with some other junk, admittedly. It just doesn't look like 90 days, even with your situation. That's what I'm trying to understand.
It's the doors.
Yeah, we
So behind
have
that
doors, we have a mattress, we have a bunch of heavy metal shelving that are back there as well. On the side of the shed, which I don't know, I don't recall seeing in the photos, we do have a few things like a bike and some other debris on the side of the shed as well that needs to be rectified. It's just the reason why we asked for the 90 days isn't because of the amount of things. It's being able to get everybody scheduled, especially with the holidays coming around. And my family has their own 2 children as well. So everybody runs on different schedules. So I didn't want to say, hey, we can do it in 30 days. And then unfortunately, I fall short of that expectation. I definitely want to get it rectified. We don't like to look that way or live that way, but that's the reason why we requested for the 90 days, just so I can make sure I can get everybody together on the same page and get it rectified.
And then if I can just add real quick, for the long time too, is because with the family, we could just hire someone, come and pick it up, and it'd be gone in a week. We don't have the funds to do that.
Yeah, I'm on
I
workman's
can't work.
compensation right now, and
Yeah.
because we have 2 autistic kids, and they have appointments left and right, and
I'm the sole person that's doing everything because he's wheelchair bound and bed bound. So that's why we've been struggling. And I've been trying to do it on my own with our teenage son, using our trash service with what I can and our vehicle with what I can. But like he said, we have 2 autistic kids, so I'm constantly going to appointments with them.
Well,
with
here's what I'm
him.
gonna do. I've never, on something this small, I understand y'all's circumstances. I'm not gonna give you like 2 weeks or something, but I'm not gonna do 90 days. Here's what I'll do in light of first of all, what's the county's recommendation?
$50 a day.
And is there anyone from the public who wants to be heard on this case? All right, what I'll do is grant, I'll do 75 days. If it's not brought into compliance as ordered, $50 a day.
okay.
Okay.
Thank you very much.
Just procedurally, were you sworn in? I don't remember you
No.
raising your hand. Could we swear her in and have her say everything she testified to is under?
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And your name?
My name is Caitlin.
Thank you, Kate.
And everything you said before, you'll say now under oath?
Yes. I
Okay.
So is everything that you've testified to at this hearing true and accurate, also given under penalty of perjury?
Yes, sir.
All right, thanks. That's the end of the hearing. Thank you.
All right, thank you so much. Y'all have a blessed day.
Thank you.
Next case on today's agenda, Horace and Tina Davis, case number 2024-1766, Code Officer Erica Olson, page 11 of your agenda.
morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your names?
Horace Davis.
Tanya Davis.
Thank you.
Thank you. I'm ready.
Erica Olson, Citrus County Code Compliance Officer. Case number CE 202-401-766, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31, Alpha of Citrus County Code Ordinances. This property is .27 acres and is zoned rural residential, mobile home allowed. Address 6715 South Frankfurter Way, Homosassa, Florida. Property owners Horace and Tanya Davis. Good service, signed, certified mail receipt. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on 3rd October 2024, corrective action inspection on 17 October 2024, and copies of my final inspection conducted on 19 November 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of signed certified mail receipt, and a copy of the pre-hearing order.
Okay. Ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence at the hearing today. Is there anyone from the public who's going to want to be heard on this case? I don't see any response. Any objection?
No.
All right, and are y'all contesting whether there is a violation today?
No.
How much time do you think you need to correct whatever it is?
I say maybe 30, 40 days.
Okay.
Because my husband does have has a back issue. I'm not saying this happened overnight.
Yeah.
It's been a while. And we're like trying to clean up and whatnot here and there, but he got injured. Well, we don't even know what happened. He has a back injury, a leg injury, so he's limited on what he can do. And it falls on me to do the lifting or get someone to come and help.
Sure.
And I do want to say that every time we do go outside to clean up, we have an audience, the people who called on us.
Okay.
There's things being said, so you don't want to go out back because of that. We have a discrepancy with the fence and the property markers, so we're working on that.
Okay.
So we're trying to get it done.
I'm hearing what you're saying. So
But-
you're saying 30 to 40 days.
Yes, sir.
And I'll just need to see the photos. I'm admitting the documents as exhibits A and B as evidence.
And we have cleaned up quite a bit.
Yeah.
And we were told what, the things that needed to be done
Mhm.
yesterday, so.
Okay.
I'm working on it.
I thought we were gonna start showing the,
We're gonna.
No, I'm just curious. All right, let me just take a look at this. There's some good stuff back there. If you ever need to get rid of one of those fishing poles.
Yeah, and he's a tinker, so, he likes to keep it because you might need it later. And I'm like, just throw it away because we don't need it. So,
Well, look, I think you've conceded there's an issue here.
Yes.
And let me ask you this. It still looks like there's quite a bit. What's the county's recommendation, first of all?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per violation along with administrative costs to begin after the date you deem sufficient to abate these violations.
Are the mowers still back there?
Yes.
Some
are.
Okay.
we took a
And
lot.
what's your plan to get rid of that stuff?
Well, we've been putting it on Marketplace and selling it, so
Okay.
getting rid of, so it's slowly, there's a go-kart back there we're waiting for the person to
I
come
see
and
the
pick it
go-kart.
up,
Okay.
So we're getting rid of it if it's not.
That's probably how you hurt your back. You probably had one too many.
So, and we've taken quite a bit of stuff to recycling, because if it's not, we get rid of, load
All right,
it up, get rid of it.
I'm concerned that 30 days isn't enough. What I'm
Okay.
gonna do is I'm gonna give 45 days to
Okay.
bring it into compliance. There is a violation. If it's not brought into compliance as ordered, I'm actually giving you a little more time, but I'm also gonna go a little higher on the fine if it's not brought, and here's why. This is an old case.
Mhm.
It's old. You know, it goes all the way back to March, from what I can see.
Oh, well, we just got the paper stuff on October.
No, sir. It doesn't go back to March. It's just how
The photos, the
it's
dates aren't
military,
accurate?
so you have to swap. I've corrected it in my phone.
It's not military, it's Jonathan, that's what it is.
I'm glad somebody other
he's-
than myself recognized that.
Oh, so in fact, this
It's
is not
10.
March 10th, this is
Correct.
October 3rd.
I just- we
Okay,
just got
and
our
you did
first
say
thing in
that in your
October.
testimony. I remember you said 3rd of October. All right,
Almost
so
panicked there a
I
little bit.
checked that. I'll follow the county's recommendation, 45 days.
I was
50
going to.
40. Okay, yeah, and I definitely want to hear from the public. So I thought I asked if there was someone from the public, and I didn't see any. Oh, no, absolutely. If someone came here to be heard, I'd love to hear from them.
Do they know?
I'm not going to twist your arms. Sounds like you have a role in this.
Could you folks move over a little bit and let her?
I am the neighbor that called.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Lisa Demicoli.
Thank you.
I am the one that called.
Okay.
I've been dealing with this for over 10 years. It got worse and worse. And it just something needs to be done. I
Now-
don't want the hard feelings, just something needs to be done.
I understand. Well, look, it is a violation of the code.
Yes, sir.
We are going to issue an order
Yes,
on
sir.
it. But I guess my question to you is, you heard some testimony about, it being difficult to, what's your perspective on that?
They have a son there that helps. He's out there, he never has the belt on. He was out there also helping do it. My son and I, we've tried to keep things clean. You can look at my property, I try. And I told my son, when they're out there, don't say nothing, because both parties has said something. I'm not innocent, they're not innocent. Because when they had some people to come over, they made me think they were with the county, saying that I'm on the property line. So when my home burned up in 2007, I had to have a different home. They had to come out. They had to put 4 things in the front, 2 in the front and 2 in the back to show my property line. I put a stockade fence up. I tried to talk to him before I called code enforcement. Obviously, you could see how horrible the fence is. Rotted into hurricanes. So I was trying to take it down. He decided to come and put up a couple of panels on my property, and they fell on my shed, and there's pictures of it. Nobody wanted to move it. Well, now the fence is down because I'm putting a chain link up. They had an issue with the property line. I said, I'll give you 30 days after they had somebody to come out already saying that I'm on their property. Nothing's been done. So the other day, I decided I'm gonna start putting my fence up, and I did.
Okay. All right. Well, I appreciate your feedback. Is there anything else you'd like to say?
No, sir. I mean, to this day, I'd still welcome them to my church at First Baptist Church in Homosassa. I don't want hard feelings. Just something needed to be done.
Okay.
It's been going on over 10 years.
All right.
Thank you.
Is there anyone else from the public who wants to be heard? Okay. And actually, I'd like him to come up to your podium, please. Please come up to this podium. You guys should be able to stay here, but if you can, try not to react. You'll have a chance to respond. Thank you, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And please state your name.
My name is Frank Demicoli.
Thank you.
We're divorced. I've been going to that property for years, on and off, and it is a disaster back there. And the problem is, what I've seen more than anything else, there's a rat infestation because of all the junk. You know, you go tap on that fence and all the rats just come running out of their yard. That's really all I gotta say. It's just a disaster.
Okay. All right. I appreciate that, sir.
Thank you.
Is there anyone else from the public who wants to be heard on this case? All right, I don't see any others at this time. So ma'am and sir, I do, you do have a right to
Yes.
tell me feedback based on the public input.
Okay, about the rats, they called the health department twice. I've had the health department in my backyard. We have a bazillion stray cats around our house. The health department, I even have them on Ring doorbell talking to the people to my daughter-in-law at our house. And they were like, they went in our backyard, there's no evidence of it. We never had a rat problem. We do live behind a store that has a dumpster. We also have neighbors down the road who have farm animals in their backyard. So they do run along across the fence line, but they don't come from our house. We've had it in, we've paid for, pest control, but there's nothing at our house. That health department cleared us 2 times. They said there's nothing here. Yes, our other neighbor's house is overgrown. We try to help them mow their grass, but it didn't come for us. We had a house down the road that was demolished. There was a lot of rats in that house, but it's not from our house because the health department cleared us twice. And as far as the surveying goes, we have not had a survey done yet. I am contacting, and my brother and my family came over just to put up new panels where they were fallen on the existing fence line that was there.
Mhm.
But according, I'm going to, there's further things I'm looking into, but the back property line is, like I said, it's a ongoing thing right now.
Okay, and
I am getting a survey company to do my own survey to establish that line.
All right, well, that's good.
And I did
I
call
don't
the
know
police
that
and
that's
all that,
necessarily
I know it doesn't have
something
to do with
before
this,
me.
but-
Yeah, but
But since she brought it up, I was going to, and
Well-
we never said nothing.
No,
It
that's
wasn't-
fine, yeah.
No one went, my brother did not go on their property without her permission.
Again,
She
not
get-
before.
you know.
Yeah, I get it. So,
So-
here's what I guess I
And
would
yes, there
tell.
is
I'm
junk
sorry,
in the
ma'am.
backyard, sorry.
If you don't mind. What I intend this to be is the final,
Yes.
resolution, because, regardless of the time I allow, whatever, if it happens again, it becomes a repeat violation. I
Yes.
want to explain what that means if you don't know. If there's ever a repeat violation and the county confirms that by inspection, then what happens is when it comes before me again, I have to assess a fine from the day that they see it without giving you a chance to fix it. So for example, if they find it, on December 1st and then it comes to me 2 weeks later in a hearing, I will assess a fine that's likely going to be high for each day that it was in violation as a repeat, before you even get here, right? And then I'll assess a fine to the extent that it hasn't been fixed from that day forward, which will be even higher than that one. So this graduated increasing fine structure, the idea is that the threat of it keeps the property in violation once it's fixed. I am concerned that there's so much stuff back there that just 2 or 3 weeks is not going to be enough time. That said, I think that whether you're right or wrong about the rats, whether they come from somewhere else or not, this kind of an issue does give them habitat or a place to hide temporarily. They're not emanating from your
Right.
house. But it could give, from what I've seen, that could be a place that they hide at night or something like that. And that's part of why these, not to belabor the point, but that's why we have to stop it just this time. So I'm going to keep the order as it is, and hope that this will be the final resolution. Okay?
Thank you.
All right, thank you. 50, well, the county's recommendation was $50 a day.
Oh, I thought you said you were gonna raise it.
I did say that, actually. So I am going to make it $100 a day.
Thank you.
Even though it's our first offense?
Even though I gave you more time. So
Okay.
I expect it
So how many
done,
days do we
but
have?
there's got to be 45.
45,
Yeah.
okay.
But if it's not brought in, that daily fine occurs, and if it comes before me again, I can also order a much stronger means of correcting it that hopefully we won't need to.
It'll be fixed.
Okay? All right, thank you.
Next case on today's agenda, Taylor and Jamie Gill Sims, case number 2024-1218. Code Officer Cody McGuire, page 16 of your agenda. Expert on the case, Technical Services, Tiffany Crosby.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning.
Morning.
Yep.
All right. Cody McGuire, Citrus County Co-Compliance Officer, case number 2024-01218. Site improvement plans, 4001. A site improvement plan shall be required for any development purpose on improved land. Address is 5425 North Laura Denise Drive, LaRue Denise Drive. Property owner is Taylor and Jamie Gill Sims. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on July 9th, photos taken during a corrective action inspection on October 7th, 2024, and photos of my final inspection conducted on November 19th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Exhibits A and B are admitted as evidence. Is there anyone from the public who wants to be heard on this? All right, I don't see anything. Are we on Jonathan dates or are we on regular?
Regular dates.
Okay. Let's see here. All right, please proceed.
All right. On July 9th, 2024, I conducted initial inspection and observed a large amount of material of earth in what appeared to be a pond. On October 7th, 2024, a corrective action inspection was conducted and no permit had been applied for. As of my final inspection on November 19th, 2024, the property remains in violation and no permit has been applied for. I've had no contact with the property owners.
How big is this parcel?
That one's acreage. I don't remember exactly.
16.09.
Wow, okay. And do you have any expert testimony you wish to offer?
I do. Tiffany Crosby from engineering.
All right.
The concerns we have is that we are seeing modification that is involving a pond. The area has low contours, so if we're touching into the water aquifer level, we do have some concerns there. And that would have been reviewed for if the site improvement plan was submitted.
What are the concerns exactly? Like if it, I mean, I'm just a lawyer, so.
Oh, no, you're fine. If you
No,
are-
I'm not. Things really have to be explained to me. So, I mean,
I'll
I
be
understand
careful.
we're close to the water table and everything, but what is the concern exactly?
Okay, I'll be brief because I can talk all day about it.
Okay.
So when you are exposing the aquifer levels, you are susceptible to more pollutant loadings that could be affected. That's where we get our drinking water from water wells. That's where we have other surface waters that make this way out to like, depending on what watershed you're in.
So you're worried about contamination of the water table from the pond?
Yes.
The quote-unquote
Well,
pond?
if you have an exposed area to an aquifer, you could have runoff from the property throughout the area. Anything could get into that aquifer table. It's just it's like opening up a lid and you've exposed it. So that is the concern. We would make sure that during the improvement process that you are not tapping to the aquifer. There's other permitting requirements that need to be.
I guess my struggle is just like, it's just water though. So like, what does it matter if it touches the?
If it's surface water, it's not just water that's on your property. Your stormwater and aquifer levels are not just within the jurisdictional boundaries of your property. It affects the whole community.
Okay. All right. But there's really no inspections, no permits. Though they applied for one. Is this under review?
There was no permit.
Oh, there's never been a,
No.
I thought I heard.
They would benefit from doing a site improvement, because then that's when we would review to make sure there's no, what we would consider an illicit discharge or connection.
Has there been any contact at all with these people? Okay.
And Mr. McGuire, if we could clarify, did they build a house on this property?
The house was built on the property.
Was there a permit for the house on the property?
Correct.
Did that permit include putting a pond in?
No.
Has a separate permit ever been pulled for putting a pond in?
No, ma'am.
Okay.
I just don't know what they're doing. Okay, well, what does the county want me to do?
A daily fine of $250 a day.
And what would they have to do to abate this?
Submit the site improvement plan?
And get it approved?
Yes.
So you're okay, like, it's possible that it could be approved?
It depends on what they submit to us
Right.
for approval, but
But what happens if it's not approved? Would they have to remove or fill it in, and do they need a permit for that?
they would have to restore it, so they would have to do some kind of, site modification permit.
So either way, at this point, they have to get approval from the county to fix this, one way or the other. Whether it's to ratify what's already been done with conditions or otherwise, or to fill it in.
Yes.
Okay. When did this case start?
July 9th.
Do you have immediate health, safety, sanitary concerns? I mean, it sounds like you do. I don't.
We have a concern from a stormwater standpoint. We have an NPDES requirement with the Department of Environmental Protection, so we have to make sure there's no illicit discharge or connections coming from any surface water. That's wetlands, waterways, in this case, groundwater table.
To me, this is a not run-of-the-mill type violation. I do think it veers more towards into the serious kind. Not that they're not all serious, I mean that there's an immediate health kind of concern. I'm really kind of surprised. And the mailing address is the house itself. Have you seen any activity on the property? Are they there? Do you know?
There's vehicles that are there and gone.
And have you posted?
I have received good service on that.
Yeah. All right. I'm going to grant 14 days to bring it into compliance. If it's not brought into compliance in 14 days, a fine of $400 a day will accrue.
Thank you.
Thanks.
Next case on today's agenda, Lilia A. Denisova, case number 2024-1652, Code Officer Julie Wilkinson, page 12 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your names?
Yes. Yaroslav or Yogi.
Okay, and?
My name is Lilia.
Thank you.
Good morning.
Good morning. How are you?
Good so far. I just read a book where they were talking about Yaroslav the Wise. Have you ever heard of?
Yeah.
Yeah.
That's not me.
It's a high burden to try and meet, but
It
you
is.
know, yeah. But my name is Christian, and so that guy was on the cross. Anyways, go ahead.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 24-01652, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 2911 West Pompano Lane in Dunellen, Florida. Property owner is Lilia A. Denisova. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 19th, 2024. Photos from a corrective action inspection on October 18th, 2024. And photos from my final inspection conducted on November 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, sir and ma'am, I'd like to ask you to take a look at these documents and okay. So exhibits A and B will be admitted as evidence. I assume you're not contesting that there's an issue.
Nope.
How much time do you need to fix it?
December 9th?
December 9th?
Yeah.
Okay.
I've never had anyone give in all the years a specific date. So
It's a Monday.
First of all, let me ask if there are members of the public who want to be heard on this case. I don't see anybody. Ms. Wilkinson, I mean, based on what has been represented, and frankly, what I can see, it doesn't look like that's infeasible to me. So, do you have anything else to add?
Well, first, I made a mistake on my testimony.
Yeah.
The final inspection was conducted on November 19th,
The
not the
19th,
18th.
okay.
It was an illegal dump. Somebody dumped this stuff there. It's a vacant property. It's not very many items, but it
No.
is going to require a trailer, but I think it could be done fairly quickly,
I
yes.
agree. This illegal dumping thing is
It's crazy.
getting out of hand.
Yeah.
It's getting out of hand.
The question we did have is, you said for repeated offense or something, we don't have a way to monitor it.
That's a very good,
So
that's a very interesting point.
my question would be, so we are gonna put a fence on it, but the problem is there's a road that goes through the middle of the property that everybody in the community uses to drive on it. And I was worried that if we block it off before we put a house or a domicile there, that they're just gonna
Well,
destroy it.
Here's what I'll tell you is, I'm allowed to take into account who is responsible for the
Okay.
violation. And now, the county in its code, and we've been through this many times over the years, has the right to go after you, though, regardless, because the idea is you have responsibility for maintaining the integrity of the premises. I have never been presented with an illegal dumping repeat situation, so I can't prejudge, but I will say that I would always take that into account whether or not I find a violation on something like that, okay? What my successors might do, I have no control over, but that's, if they fire me and I don't know. All I can tell you is the way I look at it. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the day you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We also asked special master additionally to find that it is a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
That is the lowest amount the county ever asks. I'm gonna grant you 30 days to abate the violation. You just never know with the holidays, so, and if it's not brought in compliance, $50 a day.
Yeah, well, I went out there October 25th, but my truck got stuck. My
That's what
four-wheel
I'm
drive
saying.
didn't work, so I was like,
Honestly, you
"Ooh."
never know, so,
Yeah.
all right, well, good luck.
All right.
Could you please repeat the number of days?
30.
Thank you.
We're all set?
Appreciate it.
Hey, guys.
Next case on today's agenda, Michael DeGanis, case number 2024-1647, Code Officer Julie Wilkinson.
She's already sworn in. Oh, you're an attorney.
Yeah.
I'm sorry.
Oh, okay. Good morning.
Good morning. Eric Husby for Michael Doganis.
Don't take anything I say about lawyers as applying to you. I'm really talking about myself.
I'm
so.
sure I've heard and said worse.
Well, welcome. So you've heard how I normally do things. I don't know if you have something like a motion to dismiss, I would take that up first, but otherwise, I just really want to hear what the county has to say.
Okay. Well, I mean, not really. I think we've spoken ahead of time. I just let the county say
Okay.
their piece, I suppose, and then I'll
All right, that sounds good.
respond.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 24-01647, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 7032 South Rudolph Point in Homosassa. The property owner is Michael DeGanis. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 12th, 2024, photos from a corrective action inspection on October 3rd, 2024, and photos from a final inspection conducted on November 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, well, sir, I do have to have a factual basis for this, so I would ask that you take these documents and let me know if you have any objections to them being evidence here.
I don't actually, but upon when it's my turn, I'll provide some additional information.
Fair enough. Is there anyone from the public who's going to want to be heard at some point on this case? All right, I don't see anybody. Exhibits A and B are admitted as evidence, and I'll let you proceed with your case.
Yes, I've been in touch with the county on this issue, not per se the representative here today, but my understanding is, and I also presented photos, which I probably should have printed and brought here, but they're not going to be necessary, I don't think. I provided photos of the attempted cleanup, because throughout the period of time to date, there were multiple attempts to clean up. Mr. Daganis sent folks out to remove debris and such, and I had reported myself to the county that the material had been removed. We were of the understanding that it was in compliance. So I contacted the county. The county sent another person out on an expedited basis, very nice of them to do that, and noticed that there were still a couple items remaining. As of the day before yesterday, there were I was told there were tree branches, there were some cinder blocks, about 15 cinder blocks, and a board, a piece of plywood underneath a canopy, sort of a carport. I don't know if that's what you see, but it's like a structure, open structure where you could park something under.
Yeah.
I was told that the carport doesn't need to go, but the board, the plywood underneath it did need to go. So I instructed Mr. Daganis, go ahead and get rid of that. So I was then told the ad had done that, recontacted the county. Someone else went out there yesterday, I believe it was, yesterday morning, to try to see if it was cleaned up. The brush from the storm, which were some branch work or branches that had fallen, were taken to the road, and that's where they are now, I think, for the county to come by and pick them up with the truck that picks up that stuff. The cinder blocks were put in the back of a truck that was parked on the premises. And then the board was removed. So the board is now gone, cinder blocks are in a truck, brush is out at the street. I was told, though, that the cinder blocks need to go off the property. We just haven't had time to get rid of them. And but the board is gone, and then as long as the brush is picked up from the street, that's fine. So my understanding is this is basically, in effect, resolved. But I'm not going to bother with opposing the thing, but just so you have the context of it, I think 30 days is plenty, and my client's going to get rid of the last bits. We're operating cooperatively with the county to comply, and that should be the end of it.
Yeah, I don't imagine, I try not to crush people over the holidays unless there's a health concern, but what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the day you deem sufficient to abate this violation.
Normally I would do 14 days. I am going to do 30 just because of the holidays. And also they've obviously made efforts.
Yes.
So everyone's working in good faith. So I'll adopt the county's recommendation, grant 30 days, and that's it.
More than enough. Thank you very much.
Thank you.
Next case on today's agenda, Philip Steinhauer, case number 2024-1496, Code Officer Brandon Norman, page 29 of your agenda.
You might think it's bad. Are you Mr. Steinhauer?
I am.
You might think it's bad being an S and being towards the end of the alphabet, but try being a W. Okay?
Good
Or,
morning.
I'm sorry.
Sorry, you have not sworn me in. No, sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Mr. Steinhauer, please state your name.
Philip Steinhauer.
All right.
Okay. Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-04196, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5828 East Kimbrier Lane in Inverness, Florida. Property owner listed as Philip Steinhauer. I have good service via posting at the property in the Lecanto Government Building, and I'd like to authenticate the following documents requested and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on August 26, 2024. a corrective action inspection done on October 1st, 2024, and my final inspection done yesterday, November 18th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of my posting affidavit, as well as a photo of the posted notice of hearing at the property.
Fred,
Yes,
what
ma'am.
was your last inspection?
It should have been, I apologize, I misspoke, November 19th,
Okay.
2024.
All right. Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And let me know, are you contesting whether there's a violation or not?
No, I'm not.
Okay.
All right. What was this picture taken? I mean, what is in violation there?
We can go over that. This is just whether or not you can
Okay,
test the
yeah.
authenticity of it.
All right, I didn't hear any objections.
No, sir.
Well, sounds like we'll talk a little bit about them. I think I already asked. Is there anyone from the public here? No, okay. All right, without objection, what's been proposed as exhibits A and B are evidence. It sounds like Mr. Steinhauer is not contesting, you're not contesting that there
Not at
is
all.
a violation. Before we get into the details, how much time do you think you'd need just to bring the property into compliance, based on your understanding of what's going on?
Well, I'm not exactly sure what I'm in violation of right now.
Okay,
You know
then,
what I mean?
Mr. Norman, go ahead.
Certainly. On August 26, 2024, I conducted an initial inspection for a complaint of junk and debris. The property was in violation due to trash, discarded materials, appliances, and other junk and debris items throughout the front and side of the property. The property remained in violation at my inspection done on October 1st, 2024, and as of yesterday, November 19th, the property remains in violation.
Now, Mr. Norman, I see, I'm gonna walk through the photos a
Certainly.
little bit. I see pretty good photographic evidence in August 26th behind the airboat. I assume that's what you intended to take a photo of. There's some debris out there.
So generally, when I take my photos, I like to do an overall, and then I'll zoom in and actually identify the items that are in violation.
Now, I'm curious, I see a photo on August 26th where there's like a bike and then some tires and some other things. Are tires that have rims in them considered, from your perspective, junk and debris?
It's an auto part, so if it's
Okay.
not stored properly, then yes.
I had thought, and I'm just going off my memory, I thought that previously the county's position was that if it had rims in it, that it was like usable and not necessarily. But I'm not saying that, we'll get into that.
Certainly.
That's the county's position on this case. And then I have photos on the other side of the property with a trailer, and then I see another pile of kind of debris. So I see three main areas in your initial photos, and then I go to October 1st, and it looks different. There's furniture on a trailer. Is it the county's position that the furniture on the trailer is?
Yes, because it's exposed to the elements.
And then I see, I'm not really sure what it is, a raft or?
Tube.
Tube.
Boat
Okay.
tube.
So that's something you're dragging behind a boat?
Right.
Yep, okay. And is it the county's position that that's something that needs to be stored?
It is, yes.
Okay. Then I see pallets. What about pallets? Are those considered junk and debris?
It really depends on the situation. If it appears to be discarded, it is then junk and debris. I like to tell people all the time that if you have construction materials or things like pallets, because I know they can be repurposed.
Right.
If they're stacked up neatly in one part of the property, typically we give a little bit of leeway on those things.
And then looking at the photos, was yesterday the 19th?
Yesterday
Yeah.
was the 19th. yes.
So photos taken yesterday. Tell me what you believe is in violation as of yesterday.
So along the right side of the property where that first initial photo is taken, there are a couple discarded items, some sort of box-like structure that's kind of falling apart. There's also a lot of cardboard boxes and stuff on the back of a work truck that's parked in the yard, open to the elements, as well as different materials. I saw parts of a garage door laying on the left side of the property. And then in the very front yard, they have a burn pit with just trash piled on top of it, which we shouldn't be
I am
doing.
kind of mystified by the burn pit.
We shouldn't be doing that anyway.
I mean, what do you do? I mean, why is that stuff all just stacked there?
There's nothing in the pile right now. I mean.
Okay.
And that building he's talking about, it's actually a well house on top of a well. Okay.
The box?
Box, whatever he's
Yeah.
calling it, correct.
So you're saying that's what?
That's like a little well house cover, covers the well.
I see. So has that always been there?
Yes, been there since I bought it.
What's it made out of?
Plywood.
Okay.
Due to the items that are always over there, I've never observed it before.
Well, I do see the box material near it. There's some kind of discarded box material.
Now, I do work out of my property, you know, like, I'm not gonna say that I wasn't I've been in violation for sure.
Okay.
But I went through significant cleanup over there.
Yeah.
And, I mean, I think it's, you know, being kind of tacky now, you know, in my opinion.
Well, we have to walk through it because I don't want to set you up for failure. You know,
I don't wanna be
think
failure.
I think you need clear guidance on what, even as a technical or a tacky matter, violates
Well, I've spoke to him in reference to this. He never mentioned anything about my enclosed trailer. He said something about registration. Every one of them vehicles and vehicle or vessels I use on the water, every one of them are registered. He was incorrect with that, and I told him that he needed to go down to.
Well, whatever the case, he's not here on a vehicle case. So it sounds like y'all sorted it out.
He insinuated that I didn't have my stuff properly tagged.
He's referencing other cases.
I know
that
he
have
is,
since
and
abated.
that's why I'm saying you actually won that. You know, you worked with him. It's not before me.
I'm not trying to work against
I know.
him.
I'm just trying to say that. Look, you know, that one's not really an issue. But what I want to do is I want to, just so you know, I want to read the code section first, so you have an idea. And so this is under section 20-31A, and here's what it says. It is unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter except junk stored in enclosed litter receptacles like trash cans or in a completely enclosed building, which I think would include like a garage with a door down, something like that, except for junk which will not fit into trash cans and which is set out for no more than 48 hours for pickup. Recyclable materials stored in receptacles, junk stored in a junkyard, blah, 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 blah. And then to understand, well, what is junk? I mean, what are they defining as junk? There's a definition here. And what it says is, junk shall mean any abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts. So that's why he's saying that the tires essentially are used automobile parts subject to this. Used or non-functional furniture or appliances, or used and non-functional tools, equipment, and implements, but shall not include compost piles for blah, 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 blah. So the long story short is, the idea behind this ordinance is you can have whatever you want as long as it's stored in something.
Okay.
Okay, but this also explains the boxes, and I know what you're saying. Maybe there's a miscommunication or no communicate, whatever the case. But boxes that are, even if they're in a trailer or in the back of a vehicle or something like that, because they fit that definition of junk, they're going to be subject to it. So.
Okay, well, that'd be my misunderstanding there, because like, I had previous been convicted, or they came and summoned me for this. So, talking to that particular guy at that time, he said, well, get yourself a trailer, put everything on the trailer, and that will take care of the stuff being on the ground. So that's what we've done. Now, sometimes I have to use that trailer, so I have to unload, to reload, to unload, and that's when, I'm in violation of that. Since then, I'm not gonna, I'm not gonna let the doors compile there anymore. I've just got another location, so, I'm not trying to, fight the system.
No, you haven't, but that's why I just want to communicate and help you understand what the county's saying and why I'm ultimately going to confirm that there is a violation.
Okay.
But it also doesn't seem like you would need that much time. This also does not seem that bad. How much time do you think you would need to abate this?
30 days.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. It was selected based on the actions of the property owners once they were advised of the violation and it's appropriate given the severity of the violation and the respondent's actions relative to the violation. We'd also ask the special master to make it the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I just want the county to be clear. I'm not finding that the well cover is a violation.
No, that's okay,
Okay.
because I haven't had any contact with him on this particular case. Again, this is my first time
I just want to
seeing
be clear
that.
for the
So.
order.
There was pictures taken yesterday, correct?
Yeah.
And what is in violation in your, from that point?
Well, if you would, direct your comments to me.
Well,
What
if
I'm
you could-
going to be finding is that anything subject to the code is a violation. So I'm
We
not just holding
understand.
myself to what I see in the photos. I think anything, because there could be new stuff as of today. But that said, what I see is, in the burn pile,
There's nothing on the burn pile right now. It's all been
well,
burnt
okay,
down.
but it's there here, so, and then also, let's see, discarded box material, cardboard on the side yard.
There's
several-
no cardboard on the side right now.
Which is
I
quite a
could-
bit, and then, let's see.
Next to that black enclosed trailer, that's, it appears to be like a truck rack. That would be considered an auto part because it's not.
Yeah,
actively
I
being
also see
used.
the discarded, I don't know, are they doors?
Those are
they
garage
pieces of a
doors.
garage door?
Pieces of garage door along the side of the house.
That qualifies under the ordinance. So really, just this kind of stuff has to be stored, in a garage or other shed, something like that.
Good.
Okay, I adopt the county's recommendation, fine amount if it's not brought into compliance in 30 days.
Thank you.
Good luck.
Next case is Carol L. Thomason, case number 2024-1661, and case number 2024-1662, Code Officer Erica Olson, page 32 and 33 of your agenda. Expert on the case is Joanna Coutu, Land Development Director.
And we are bringing both cases at once?
Yes.
Okay.
Yes, sir.
Hi.
Hey, howdy. This is more entertaining than a John Grisham novel.
That's a lie. And so
Just
if that's
come on,
if
you like-
that's
you
your
already know.
credibility, I'm already doubting your testimony.
Do you swear to tell the truth, the whole truth, and nothing but the
Yes,
truth?
ma'am, I do.
Can you please state your name?
My name is James Joseph O'Keefe.
Thank you.
Mr. O'Keefe, I see that the listed owner or respondent on the property is Miss Carol Tomlinson. So what is your basis for representing?
So, it's kind of a crazy story. So, I'm her son.
Okay.
Now, the complaint is the other son.
Mm-hmm.
So, my mom is doing 10 and a half years in prison for the death of my dad. They were drinking and driving. Don't do it. No good. No bueno. So, it was kind of, we weren't expecting her to go, whatever. So, my brother's...
Is she in like vehicular manslaughter or something like that?
Yes, sir.
Really?
But she was drunk, knowingly driving drunk, so...
And he was in the car?
Yes, sir.
Wow, I'm sorry. Okay.
So it's like I've lost both parents and I got
Right.
a butthole brother that's... So I actually live a couple hours away. I was not aware of any of this till like yesterday. So, and I'm here now. I'm sorry. I gotta get an eviction. Or I guess
Is there
or
someone
the-
in the property?
Yeah, my brother's there.
Oh.
So it's like a family,
Okay.
my mom's tired of it, but he just won't leave.
Okay.
And now I guess this situation, I was not aware of the condition of the property. My mom had a beautiful home. And the pictures I guess my sister sent me is terrible and I'm sorry.
I'm sorry, I really thought you were your brother that I spoke with yesterday. You guys seem very much alike. I'm like, what's going on?
Well, so you have no reason to doubt his story. All right, so sir, I really just wanted to understand a sense of your standing. I'm satisfied that you have standing to
Yes, sir.
be here. As a technical matter, you don't have a power of attorney, correct?
So me and my sister do, yes.
Oh, you do have a power of attorney for your mother.
Yes, to speak on behalf of my mother, and I have.
It's a document that's signed and witnessed and notarized.
Yes, sir.
Okay.
So, yes.
Okay. I'm going to allow it just for the purposes of the hearing, but I really want to hear from the county then, just so I understand what's going on in the county, on the property.
Okay.
Thanks.
Erica Olson, Citrus County Code Compliance Officer. I'm going to present these cases together. Their case numbers 202-401-662 and RV occupancy, a violation of Citrus County Land Development Code Section 3140, temporary uses. And case number 202-401-661, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of Citrus County Code Compliance.
Okay.
Citrus County Code of Ordinances, sorry. This property is 2.29 acres and is zoned rural mobile home allowed. Address is 6284 South Applebud Terrace, Lecanto, Florida. Property owner, Carol L. Tomlinson. Good posting the notice of hearing on the property and posting at the Lecanto Government Building. At this time, I'd like to authenticate the following documents and request that they be admitted into evidence. For both cases, Exhibit A, photos taken during the initial inspection on 17 September 2024, a corrective action inspection on 17 October 2024, and photos of my final inspection conducted yesterday, 19 November.
Ooh. Oh, I'm sorry.
No.
So there's been a corrective and all this.
Well,
It's a
if you,
process.
yeah.
Yeah, I'm sorry. I'm
please
sorry.
okay.
No, I understand the process, but it's like almost done. It's wrapped up.
No,
kind of thing.
no. Just
Okay.
please
It's okay.
proceed.
I'm sorry.
Exhibit B for both cases, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order for both cases.
All right. Actually, let me ask this first. Is there anyone from the public who wants to be heard on this case? All right. You have an exhibit A and B, and are these exhibits A and B for both cases?
Yes, sir.
But you have a different A and B for
They're
each case?
two separate
Okay.
cases, they're just same address.
All right, so, Mr. O'Keefe, I guess what we'll do is I will ask you to review these documents just so you understand what is being presented.
Okay.
Okay?
So this is one case, this is
Okay.
for the RV occupancy, these are the photos, and then
And
these
Mr. Wall,
are all the
I have actually already reviewed these. I have to step out momentarily. I will be
you
right
have
back.
I'm sorry,
spoken
what?
to
I have to step out momentarily. I'll be right back, but I've already
Have you
reviewed
spoken
these
to
him?
documents.
Okay,
Shouldn't
okay.
even straight to
Have
you.
you done
great.
anything about any of this?
Well,
Or,
the
sorry.
special master will I get to, I can't really speak on it.
Oh, okay,
until,
understood. I understand.
it's okay.
Yes, ma'am. I'm looking at the photos.
So this is just for RV occupancy.
So he's got a trailer park. Okay.
And we'll go over it, but, I mean, the only thing I'm looking for is if you have a legal objection to the documents, because I have to use them as
No,
evidence.
I mean,
Yeah.
it's proof.
Yeah.
It's there. But
Okay.
this is more fuel for the fire to get him out of there.
Did you wanna see these? These are like the
Yeah.
notices that I sent?
So, and this started September 17th. Okay. And that was the postings?
Yes, sir.
Okay.
And then, so this is one case, and then this is the other case. These are the photos and the documents.
Okay.
Do you wanna give these or you wanna wait for her?
We don't need to wait.
You good? Okay.
All right, exhibits A and B in each case are admitted as evidence. Thank you. No, that's okay, I got it. Appreciate it. All right, so please proceed with your case.
Okay. On the 17th of September of 2024, I conducted my initial inspection and I did observe the property to be in violation. That same day, a notice of violation was issued for junkyard conditions and RV occupancy, which is a violation of the ordinances mentioned earlier. On 17 October, I conducted corrective action inspection and observed the property to remain in violation. Items observed for the junk case were things like tires, appliances, piles of scrap metal. There was a mattress, and then other miscellaneous junk and debris. I did believe that someone was living in the RV due to there was a separate driveway. There was like outdoor chairs set up. And then the individual residing in the RV, Donna Barr, called me. She contacted me and confirmed that she was living in the RV.
Oh, really?
I have not had contact with the property owner, Ms. Tomlinson, due to her situation. I have, however, spoken to the daughter, Geneva, and then a William O'Keefe.
What did the daughter say?
The daughter, she said that she had power of attorney. She does reside in Tennessee, and that she was unaware of the happenings on her mother's property.
I mean, there are a lot of tires. There's, okay, and what did William say?
William, he said that his sister has been taking rent from the person living in the RV. And that is what the person in the RV said. She said that Geneva, the sister, was the one that posted the advertisement for the place.
Oh, I see. Okay. And you said it was 2.2 acres, I think.
2.29. Yep.
2.29. All right. Do you have any expert testimony that you wish to offer on either case?
Joan? Okay.
You're here. I mean,
I don't really have anything to add. I mean, it's a mobile home site. We know there's a mobile home there. The issue I have is the residents in the RV.
I'm sorry, what did you say about the mobile home? That
There's-
it's not, it is allowed?
It is allowed. It's a
Yeah.
permitted mobile home. There's no question of
It's
that.
permitted?
Yeah. The only
Wow.
thing that we have is the RV.
Do you know who got the permit for it?
I didn't look it up.
Okay.
It's been a while.
I'm just interested.
Their last permit on this site was 2013. It's been there for some time.
Okay. Yeah, so, I mean, it looks like, well, Mr. Keefe, what do you have to say about this?
I'm appalled.
Mhm.
So,
What's going on with the rent? Do you know who's getting paid?
whatever my siblings are special. So, to say the least. So, I spoke against this stuff, and my brother needed to go, and all this stuff, and so that's why I've stepped back. And they have made a disaster of my mom's home. And now I am gonna go step back in and rectify the situation.
So you don't know for sure who's responsible necessarily? Okay, no, that's fine.
Yeah.
What does the county want me to do?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day per violation, along with administrative costs to begin after the date that you deem sufficient to abate these violations. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violations. We would also ask that the special master additionally find that the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
What's your plan?
I'm headed there after this. So the thing, so I had some questions like to get an eviction.
You're gonna need to talk, I can't give you legal advice.
Okay, understood.
And what I can say is that, you know, in my experience, it's a doable process, but you need to know what you're doing. So talking to legal counsel is a
understood,
good idea.
understood. Okay, that was very eloquent. Good way of putting all that.
I don't get out much.
Yeah, that's good. That's a sidestep in a llama. I like that. But my apologies, and yeah.
Well, the reason why I'm asking about the plan is because I'm going to do two things. I'm going to find that there is a violation in each
Yes, sir.
case, and I'm
Okay.
also going to assess a fine in each case,
Okay.
but I'm not gonna do it immediately. I'm gonna give a little bit of time before the fine begins to accrue, because this can't, if all is as it seems, the fine isn't going to really deter anybody, if that makes sense.
No, because he won't pay it.
It
And
may
it will-
give you an incentive to move faster if you
Well-
ultimately are a beneficiary of the property, or just to help your mom out, but, I'm concerned. I personally don't think it's that difficult to do an eviction, but I have experience doing it. I am very concerned about the junk. I mean, I think that is something that,
Well,
it's
I
not
have,
an overnight thing.
Yes, sir. I have access to truck and trailers. I can start this, like, really start.
This is acres of junk. I
Oh,
mean,
yeah.
this is-
Yeah, so now on that note, I just can load this stuff up and take it to the dump, right?
I'm not here to
Because
tell
this,
you what you
okay,
can and
because
can't
this was
do.
my mom and dad's stuff, and now it's become,
Well,
you know,
if you have a power of
not
attorney,
the junk was their stuff. I'm saying it was a beautiful place.
if you have a power of attorney, then you
So there's the legality.
theoretically
okay.
you can do what you want, but I don't know, and I encourage
Yeah,
you to seek
understood.
legal counsel.
Okay.
Here's what I'll do. What's the county's fine? It was $100
Per day, per violation,
per
sir.
day. All right, on the RV occupancy case, I'll find that there's a violation, and I'm gonna give 60 days before a fine begins to accrue of $100 a day. On junkyard conditions, it's gonna be hard because it could be that the person in the RV is contributing to this, you know, so, but I can't let it go. I'll do 90 days, and if it's not brought into compliance in 90 days, $100 a day.
Thank you.
Okay?
Yeah. Is it possible to get paperwork from today?
We'll issue an order, but the order is gonna go to the address on the property appraiser website, which is 6284 South Applebud Terrace.
So it'll go right. Okay.
However,
Well, that's good though.
if you make a public records request, you can probably get one, so we'll see.
Understood.
Okay. No
Yes,
problem.
ma'am. I appreciate it. Your number. 'Cause I need
If
to
you go
come-
back there, Ms. Nocello will give you one of my cards. I'm pretty sure I'm like next up on the docket, so she'll give you one of my cards, and then feel free to reach out if you need anything. No problem.
Next case on today's agenda, Thomas Gallagher, case number 2024-1244, Code Officer Brandon Norman, page 15 of your agenda.
He said that he's gonna go look at it.
Okay, good morning. Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-02144, 0244, sorry. Special requirements for all accessory structures, a violation of Citrus County Land Development Code Section 3102A. This is for 10528 East Rabbit Lane, Floral City, Florida. Property owner listed as Thomas Gallagher. I have good service via signed certified mail return receipt, and I'd like to authenticate the following documents. Of course, they be admitted to evidence. Exhibit A will be photos taken during inspections on the following dates: August 13th, 2024, October 3rd, 2024, and November 19th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
All right, thank you. Exhibits A and B are evidence. Please proceed.
On August 13th, 2024, an inspection was conducted of the property for storage on a vacant parcel. Property was found to be in violation of the aforementioned ordinance due to a shed and other items on the parcel. It remained in violation at my corrective action inspection done on October 3rd, 2024, as well as my pre-hearing inspection conducted yesterday, November 19th, 2024. I have spoken to some parties who were involved in the property. Mr. Gallagher is, I'm being told, deceased. But they're almost towards compliance. They're just a little bit, there's just some other items left. The shed was removed, and then there's just some construction debris that's left over. So they're
Really
almost there,
doesn't-
but very
yeah,
close.
it really doesn't look like much is left.
Yeah. We just ran out of time is all, so. I have an expert witness as well.
Yeah, I mean, I'm curious. I think I can accept. Why do we do this? Like, why do we have an expert witness for a case like this? No, I'm curious. Like, I'm not against it. No, I mean, I want to know. Like, I don't want to trip a wire if there's some kind of case law or something that I can't accept that testimony from Mr. Norman. I just.
You can accept it, okay, you can
I mean,
accept his testimony for, you know.
I believe Ms. Cashew is here because it kind of falls under the Land Development Code, and she
Right.
is the subject matter expert. So if your
Yeah.
questions get more in depth, then
And sometimes they
this
do.
is-
Yeah, sometimes they do. So I just want to make sure I'm not doing something wrong. Well, I just think at this point, I think the case has been proven. So what's the county's recommendation?
We recommend $50 a day after the date that you deem sufficient, and the respondent's responsibility to contact us once the violation's been abated to allow for reinspection.
Okay, I'll grant 30 days and $50 a day.
Thank you.
Thanks. Oh, I'm sorry, is there anyone from the public? I don't, okay.
Next case, Salim A. Muhammad, case number 2024-1265, Code Officer Cody McGuire, page 21 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
All right.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 202401265, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 7661 West Citruswood Drive, Denellen, Florida. Property owner is Muhammad A. Salim. Good service via signed certified mail return receipt and posting at the Cantil Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on July 24th. Photos taken during a corrective action inspection on September 16th, and photos taken on my final inspection conducted on November 19th. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, a copy of the continuance letter, sanitary nuisance photos, dated August 16th, 2024, and a pre-hearing order.
Okay. All right, exhibits A and B are admitted as evidence. I'm gonna stop asking for public input because I don't think there are members of the public here. Please proceed.
On July 24th, 2024, I conducted an initial inspection and observed an RV, truck, trailer on vacant property. September 16th, 2024, corrective action inspection was conducted with little change. As of my final inspection on November 19th, the property remained in violation.
You've introduced in the exhibits sanitary nuisance photos?
From environmental.
What's going on?
It's from environmental health.
These photos were taken by environmental health?
On those two particular pages, yes, sir.
What's the issue?
Sewage.
Can you tell me a little bit more about that?
The sewage?
Yeah, what's the sewage issue?
So from what Courtney explained to me is they had no proper process of getting rid of the sewage.
Is someone living there?
Yes.
Okay. So it's not just storage per se, it's that there's someone's living out of this container.
They were. The container's now gone. What's left now is the fifth wheel with the two tents.
Oh, okay. Okay. Is anyone living there now?
Yes, sir.
Okay. Have you seen them?
I have seen him. There's actually a photo of him in one of the pictures.
Okay. What do you want me to do?
I want you to assess a fine of $250 a day.
Have you had contact with the owner?
I have. He said that he's actively trying to get them off.
Do you have any reason to disbelieve him?
The fact that he's not here today. There was 4 other additional properties that had the same thing going on, and that's the last of all the remaining ones.
Same owner?
Different owner.
Does environmental have like a case or anything pending regarding this? Okay. Well, then what I'll do is I will find that the property is in violation and assess a, just looking at the photos here, the dates. $500 fine, and it'll be 30 days.
Thank you.
Next 2 cases, Tony Michelle Spivey, case numbers 2024-1605 and 2024-1612. Code Officer Erica Olson, page 27 and 28 of your agenda. Expert on the case, Joanna Katu.
Here we go.
Yep.
Erica Olson, Citrus County Code Compliance Officer. Case number CE 202-401-605, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. And case number CE 202-401-612, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Alpha. This property is vacant. It is 0.31 acres and is zoned Coastal and Lakes Residential District Mobile Home. Address is 10720 West Woodland Place, Homosassa, Florida. Property owner is Tony Michelle Spivey. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. At this time, I'd like to authenticate the following documents and request that they be admitted into evidence. Photos taken during my initial inspection on the 9th of September 2024, corrective action inspection on 11 October 2024, and photos of my final inspection conducted yesterday, 19 November. Exhibits B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Okay. Exhibits A and B in each case are admitted as evidence. On the junkyard conditions case, did you take these photos?
Yes, I did.
I think the photos are very good evidence that there are junkyard conditions on the property at the dates that they show. Would you say there's been improvement?
No, I would
No?
not.
Okay. What's your recommendation on that case?
I recommend $100 a day.
All right, I'm going to find a violation, grant 30 days to bring in the compliance, and it'll be $100 a day. But I do want to hear what you have to say on the storage case.
So the storage case, I did run it as 2 just to try and cover all bases with storage and junk. There was a mobile home on the property that burned down, which is part of the junk case. There is an RV currently on the property. It's not the owner that lives in the RV. I made contact with her during my initial inspection. She said she was not living in the RV. She was there to clean up all the junk, but there's been no progress. There's also a boat and like a lot of crab traps on the property.
But this
and
parcel's
that's
supposed to be vacant.
correct.
So, I mean, it doesn't matter.
It
Everything's
doesn't
got to
matter,
go.
but I was just trying to encompass
Yeah.
it all so there
Yeah.
wasn't any confusion or leeway.
Do you have any knowledge, either from the complainant or otherwise, as to how long it's been this way?
I don't know how long it's been this way, but the PA does show that it's a vacant property, so my guess would be quite some time.
What's your recommendation on this case?
$100 a day and then the administrative costs.
What's the zoning on this?
The zoning is coastal and lakes residential district, mobile homes allowed.
Okay. And you said 100?
Yes, sir.
I'm just gonna do 30 days again and $100 a day.
Okay, thank you.
Yep.
Next case, Kenneth F. Eplin, case number 2024-01247. Code Officer Cody McGuire, page 14 of your agenda. Cody stepped out. Okay. Gulf Coast Parts Supply LLC, case number 2024-01680. Code Officer Erica Olson, page 17 of your agenda.
Erica Olson, Citrus County Code Compliance Officer, case number CE 202401680, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20, Tax 61 of the Citrus County Code Ordinances. Address is 1590 South Suncoast Boulevard, Homosassa, Florida. Property owner is Gulf Coast Parts Supply LLC. I have good service via signed certified mail receipt and posting. That's it, just a signed certified mail receipt, sorry. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 19th of September 2024, my compliance inspection on the 4th of October 2024, and photos of my final inspection conducted yesterday, the 19th of November. Exhibit B, a copy of the notice of violation, a copy of the hearing, the notice of hearing, copy of the signed certified mail receipt, and a photo of the notice of hearing posted on the property.
All right, then what's been proposed as exhibits A and B is evidence. So sometimes it's very clear, but let's see. Right. You took these photos?
Yes, I did.
On the dates indicated?
Yes, I did.
All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day with the administrative costs to begin after the date you deem sufficient to abate this violation.
Okay, 14 days, $150 a day.
Thank you.
Next two cases, Alice D. Pratt and Charles L. Reed, case numbers 2024-01422 and 2024-01423. Code Officer Julie Wilkinson, page 22 and 23 of your agenda.
Julie Wilkinson, Citrus County Co-Compliance Officer. Case number 2401423, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20. Article 4, Section 20-41 of the Citrus County Code of Ordinances. As well as, I'm going to run the two cases together. Case number 2401422, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 2675 South Willow Terrace in Homosassa, Florida. The property owner is Alice D. Pratt, Charles L. Reed, and the Reed Pratt Family Revocable Living Trust dated June 15th, 2001. I have good service via posting the continuance letter at the property and at the LaCanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 2nd, 2024. Photos from a corrective action inspection on August 19th, 2024. and photos from the final inspection conducted on November 18th, 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the general pre-hearing order, a copy of the continuance letter, photos of the continuance letter posted at the property, and a copy of the posting affidavit.
All right, what's been proposed as, I think exhibits A and B is evidence. Thank you.
And Ms. Wilkinson, when you testified, you cited 20-60 for 1422. Was it supposed to be 20-61? The grass?
Yes. All right, so exhibits A and B in each case are admitted. First, I'm gonna look at the overgrown lawn case. Ms. Wilkinson, you took the photos on the dates indicated on these?
Yes, sir.
Okay.
Some of the photos were conducted by, the final inspection was conducted by the director.
Mr. Trong?
Yes, sir.
Okay. All right. Well, I mean, it's pretty conclusive photographic evidence on all dates of the violation. What's the county's recommendation on that case?
Specifically the long case or the junk case? The long case, $100 a day along with the administrative costs.
Do you know how big the parcel is?
Yes. It's a 1.04 acres.
All right, I'll grant 14 days. If it's not brought into compliance, $100 a day. And then I do want to hear testimony on the unlicensed vehicle case.
Yes, sir. On August 2nd, 2024, conducted an initial inspection and observed that the RV on the property had no tag. On August 2nd, 2024, a notice of violation was issued for abandoned, unserviceable, and unlicensed vehicles. And then on August 9th, 2024, conducted a corrective action inspection, so the RV was still there with no tag. As of the final inspection on November 18th, the property remained in violation. I have not had any contact with the property owner. The property just seems abandoned.
Yeah. What's your recommendation on this case?
$100 a day as well.
All right, 10 days, $100 a day.
Thank you.
Next case, Kenneth F. Epling, case number 2024-1247, Code Officer Cody McGuire, page 14 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer. Case number 202401247, accumulation of junk and debris. Violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 15 Oaknall Street in Beverly Hills. Property owner is Kenneth F. Eplin. Good service via posting the property and posting at the Canton Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during an initial inspection on July 12th, 2024, corrective action inspection on October 15th, 2024, and my final inspection conducted on November 19th of 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
All right, exhibits A and B are evidence. Thank you. Let me just take a look at this. You took the photos on the dates indicated?
Yes, sir.
Okay. What's the county's recommendation?
$50 a day.
Have you had contact with the owner?
No, I think it's the same thing, an abandoned property.
Wow.
And the neighbor, it started out with a lawn case and then I opened the junk case. And then someone cut the lawn, but surprisingly, all the appliances remain under.
Huh. All right. I'm sorry, what was your recommendation?
$50.
$50 a day? All right,
Mhm.
14 days and $50 a day.
Thank you.
Yep.
Next case, Gulf Coast Parts Supply, LL.
We already did that.
Oh, we did that one?
Yep.
Sorry. Ronald Santaga Jr., case number 2024-1678, and case number 2024-1679. Code Officer Erica Olson, pages 24 and 25 of your agenda.
Santa Gata.
I'm ready.
Erica Olson, Citrus County Code Compliance Officer, case number CE 202-401-678, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20, Tag 41 of the Citrus County Code of Ordinances, and case number CE 202-401-679, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20, Tag 61 of the Citrus County Code of Ordinances. This property is 1.09 acres and is zoned rural residential mobile home. Address is 6225 South Esmeralda Terrace, Lecanto, Florida. Property owner is Ronald Santagata. I have good service via posting of the notice of hearing on the property and posting at the Lecanto Government Building.
What's so funny?
JC can never pronounce names.
Okay. All right. Fair enough.
At this time.
I hate to be left out of a joke.
I see that.
You know,
like,
that's,
geez.
there, you know.
He really felt like some type of way about that.
You should be at our staff because we have twice as many cases before they start
Right,
abating.
right.
It gets interesting.
At this time, I'd like to authenticate the following documents and request that they be admitted into evidence. For both cases, I have an Exhibit A, photos taken during my initial inspection on 19 September 2024, my corrective action inspection on the 3rd of October 2024, and photos of my final inspection from yesterday, 19 of November 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
All right, what's been proposed as exhibits A and B are admitted in each case. And I will ask you first about the overgrown lawn. Did you take the photos in exhibit A on the dates indicated on them?
Yes, I did, sir.
All right, it seems on all photos, it's beyond reasonable doubt that it's over 18 inches and that as of the date of the hearing, there's been no change. What's the county's recommendation?
Correct. So I have spoken with the homeowner. He is out of state, and he has said that he is trying to get back to Florida, but
I mean, did he say he was coming back soon?
he said he was coming back as soon as he could.
Okay.
Were his words.
All right, what's the county's recommendation on the overgrown lawn case?
$100 a day.
Okay,
for
14
both.
days and $100 a day.
The same for the bus, the unregistered bus, $100 a day and administrative costs.
All right, so let's talk about that case. I see in the photos that there is a bus, and you've never seen a tag of any kind?
Correct.
Did the owner concede that there was no registration or that
He
it was?
did.
He did.
He did. He told me that he uses that bus for storage.
Okay. Did he say that he had an intention to get it licensed or registered?
So I talked about that with him. He said that he didn't want to do that because then he would need to start an LLC because it is a commercial vehicle. And I told him that wasn't something I can answer to. You know, he can't store the bus there.
That's interesting.
Unregistered.
It's not a problem for this hearing, but I've seen buses like used as part of things.
Yeah, I mean, people
before.
redo them and
Right.
you know, have tons of kids or they make them into RVs.
Yeah, I don't know what
It's
Citrus
possible.
County's willing to do. All right, and you said your recommendation on that's $100 a day?
Yes, sir.
Okay, 14 days, $100 a day.
Thank you.
Yep.
Next case, Larry L. and Barbara Tate, case number 2024-1602, Code Officer Julie Wilkinson, page 31 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation. Initially observed on September 23rd, 2024. The address of the violation is 7500 West Miss Maggie Drive in Homosassa, Florida. The case number is 2024-01602. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Larry L. and Barbara Tate. They have previously been found guilty of the same violation at 465 South Thompson Avenue in Lecanto, Florida, on March 16th, 2023. That case number is 2181489 with $4,200 in imposed fines. That case was abated on March 10th, 2023. I have good service via posting on the property and posting at the Lecanto Government Building, and a signed certified mail return receipt of the continuance letter. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of fact and order acknowledging compliance from previous case number 2181489. Exhibit B, photos taken during an initial inspection on September 23rd, 2024, and photos I took during my subsequent inspections on September 30th, October 11th, October 16th, October 23rd, October 29th, November 5th, November 13th, and the final inspection on November 18th of 2024. Exhibit C, a copy of the repeat notice of violation and hearing sent to Larry L. and Barbara Tate, a photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, a copy of the posting affidavit, a copy of the continuance letter, and copy of the signed certified mail return receipt.
Okay, without objection, as respondents are not here, exhibits A, B, and C are admitted as evidence, and I'm just going to take a moment to review the exhibits. This is a repeat of a repeat.
Yes, sir.
And I do remember the names.
Mm.
Have you had contact with the owner?
No, but I've been in contact with the occupants.
What did they say?
They cleaned it up really fast, actually. And they don't really say much to me.
Well, they cleaned it. I mean, they made a big improvement, but you're saying it was still.
It was in compliance, and then it went back
Oh, okay.
out of
Okay.
back into violation.
Okay. Well, walk me through those dates.
All right. So I conducted my initial inspection on September 23rd and observed the loose trash, auto parts, scrap, and miscellaneous junk and debris on the property. I posted the property on that same day. I received a call from the occupant on the 24th asking for an inspection on the 25th, but I couldn't make it out there because I had to do storm damage assessments from the hurricane. So the soonest I could get out there was September 30th. So that's why, since he had called on the 24th to request the date, that's why I'm only asking for the fine for those first 2 dates.
I understand.
Okay. So I went out there on September 30th. He was in compliance. Follow-up inspections conducted on October 11th, 16th, 23rd, 29th, November 5th, so the property remained in compliance. However, on November 13th, that's when the property was found to be out of compliance again with some bedding furniture, and on the following day, or the following inspection on November 18th, you can see that there is other miscellaneous junk, some posts, some hard hats, some just miscellaneous debris that's throughout the property. And it appears that he's trying to hide it behind a fence.
Yep. All right, what are you requesting?
I'm requesting $150 a day for 9 days, totaling $1,350, and a fine of $250 per day from this day forward until the violation is abated.
Okay, I think that's reasonable. I will find that there's a violation. The reason why it's not a significantly higher fine is because it is a different property. I think it probably is different tenants. In any event, based on the dates of the repeat violations that are established by evidence, including testimony and photos, I'll assess a fine of $150 a day for the 9 days that the property was in repeat violation up until today. I mean, right? Because it was out of compliance as of yesterday.
I'm trying to count.
You've got the
Give me
2
a
days,
second.
September 23rd, September 24th.
Mm-hmm.
You've got the 13th, 14th, 15th, 16th, 17th, 18th, 19th. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Yes.
So I agree. And then from today's date forward, a fine of $250 a day until it's brought into compliance.
Yes, sir.
Okay?
Thank you.
Thanks.
Last case today, Unique Home Builders LLC, case number 2024.
Did we do Schumacher?
I don't have.
Oh, I debated.
That abated.
Oh, it
sorry.
debated. All right. There you go.
Unique Home Builders LLC, case number 2024-1665, Code Officer Julie Wilkinson, page 34 of your agenda.
Last one, fast one.
All right.
Now,
Okay, Julie Wilkinson, Citrus County Code Compliance Officer, case number 2401665, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 7968 North Gulfview Drive in Citrus Springs, Florida. Property owner is Unique Home Builders LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents.
I was
and-
kidding. You can take your time. That's just what we used to say when we swam and did sets. You know, your last lap is the fast one. Sorry. That was not an instruction. Yeah.
I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 19th, 2024. Photos from a corrective action inspection on October 4th, 2024, and photos from a final inspection conducted on November 18th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right. Exhibits A and B are evidence. And I will just take a look at the photos. Did you take the photos on the dates indicated in Exhibit A?
For the initial and the corrective action, but Mr. Charlton had done the final inspection for me.
Okay. So, Mr. Charlton, did you sworn an oath?
Yeah.
You sworn it? No, you don't need to move.
No.
I mean,
Yeah, I took
you already
photos.
sworn oath?
No.
No, I can. I didn't know if you wanted me to
I
get
mean, you
up
could do
and-
it right there. It's not.
Do you
Yeah.
swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Did you take the photos dated November 18th in Exhibit A?
Yes, sir.
All right. It looks like in all the photos, this is, I mean, we're talking like 3 feet, not 18 inches. Have you had contact with the property owner?
Yes, well, I've had contact with somebody named Cody who works for Unique Homes. And he said he was gonna have somebody go out there to grade, and he said that to me.
Grade.
To grade, that's what he said. He
Okay.
specifically said grade, so
Well,
I'm
maybe
like,
they have a different-
whatever. Yeah. He said that to me on October 14th, and, obviously, it's still not done.
Okay. What's the county's recommendation?
$100 a day along with the administrative costs.
All right, 10 days, $100 a day, and we incorporate all those standard provisions.
Thank you.
There are two things I want to briefly talk about, or ask the county about before we go, because it's useful for me. But number one is the weather and the hurricane stuff. Have you found that the storms such as Milton have caused code issues?
At times, or certain areas, yes.
Okay. Like trees down, that kind of thing, or is it?
Trees down and debris. But what we do is, we do have meetings beforehand, and then our officers obviously help with damage assessment, and they get to see some of the hard-hit areas. We do give some grace with those, with those type of situations, and some properties, we kind of know which ones were affected and which ones wasn't caused by the storm.
Okay. And this question is for everybody, including you, Ms. Harrison. I mean, we're going to start using a different format on the orders, which I'm happy about. Is there anything that, based on what you're seeing, whether in other cases or appeals or otherwise, that we need to be addressing in the hearings that maybe is not being addressed?
I haven't seen anything.
Okay.
I think the reformatting of the order will address the
Okay.
issues that we have seen on appeal.
Okay.
I haven't seen anything in terms of a specific finding that you have to make.
Okay.
If something changes, I'll let you know, but.
Yeah, I'm just curious.
But so far, Ms. Antrim has, succeeded on the appeals that she's
Yeah,
had.
well, that's fine. Personally, just for the record, I want the right result regardless. I'm not vested in being right, but if there is anything, I would just ask that y'all let me know. All right, is there anything else?
A different topic,
Yeah.
but something we talked about a couple meetings ago is putting the money, the fines from disturbed properties into a Beautify Citrus campaign. That is going before the Board of Commissioners on December the 10th.
Wow, okay.
So we're gonna give them the entire year's worth of fines. If they want to make it retroactive to January 1 or October 1 or whatever, then they'll know how much money they're starting with, or they can do it December 10th or January 1 of 25. So it'll be, those funds go into the county's general fund, so they would have to take that money out of the general fund and put it into a campaign. But that'll be the option before them.
So I want to make sure I understand, because I may not. Right now, when someone pays a fine, what happens to the money?
Goes to the county general fund.
And it can be used however the county wants, essentially. No restrictions, it
correct.
just goes. Is that a part of y'all's budget? Like, do y'all expect a certain number of fines that you plan on?
I don't know.
Okay. Okay. Well, and so what the change would be is that it'll go to something that is allocated and has to be, it's restricted in what it can be used for.
We would earmark it towards beautification of the county on public property. That could be a number of things. It could be landscaping, trees, wildflowers, signage, some type of way marking signs. So something that would enhance the public space, and so those funds wouldn't just be lost to the general fund. They could be a designated purpose, which
Right.
would counteract the violation that had occurred.
Absolutely. And perhaps justify, in some respect, the fines and.
Yeah, so
and-
I
and-
wouldn't be
and-
surprised if the request for fines is increased, because they now have, assuming that the board
Yeah.
agrees on December 10th, those funds will have a new home.
Okay, that's great to know. All right, is there anything else? All right, then the time is 12:22. This hearing is adjourned.